Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy there.
Got the wrong guy, and the dog was biting him.
He roughing him up quite a bit. There's a lawsuit.
9 out of 10 judges prefer watching the Recovery Addict live stream in their court.
The fireworks are not done.
I was getting commentary on the kid.
Is that correct?
Dati mihi Anglican priest service on you. Oh, for Trump's sake. I didn't ask you to interrupt me.
Good morning, welcome. Wow, that's loud and I'm quiet. Holy cow. Let's turn that down just a teensy bit. Good morning, happy Monday morning. Welcome to the Court of Public Opinion. I am the Recovery Addict. I feel like a new man today. Well, you can see why. I got my hair cut, top and bottom. So, it's my weight loss program, guys. It's working really well. All right, trying to get chat on the screen, which is, I guess, more than I can normally do. Let's see here. There we go. Bring it here. There we go. All right. Here we go. Why can I not scroll up? There we go. Got it. It's working. Where's the pinned message? I can't find my pinned message. Is that the right pin? Greeners was first in chat this morning, as everyone already assumed. Greeners, congratulations. I don't see you here now. Where are you? You'll pop up eventually. But thank you, my friend. All I have right here is sample user, who is saying that this live stream is the best, which I could, all I can do is agree with. Thank you, sample user. I got my hairs cut. I sure did. I feel lighter and my chin feels colder. I look younger. I'm quite. It's amazing when you cut off all the white hair, how much younger you look. It's crazy. It's crazy how that works. Greeners, congratulations. First in chat. The internet is all yours. I gift the internet to sample user. That's another first, Greeners. I'm not sure if I've let you know, but sample user is not a real user. I'll have to check the rules. I don't think that's allowed. Tentatively, I'm going to say denied on that motion and send it to you to internet ownership. But we'll see how it goes. Congratulations being first in chat. Anyway, Greeners, thank you very much. Babyface RA. It's been a while since I've been clean shaven. Tori the Seed Lady, woohoo, 13 whole months. Haircut looks fantastic. Thank you very much. I went to, I was going to go to like Supercuts, and I ended up going to Great Clips because I walked into Supercuts, and I walked up to the little cash register meet and greet kiosk, whatever it's called, and there was a lady there who was, I would say, clearly playing a game on her phone. And I only say that because she was holding it in such an angle that I could see her playing the game. It looked like some sort of battle, a war back and forth, maybe even like Candy Crush type, but no, not Candy Crush. Or like Royal, I forget what it is. There's a game where you battle other people and you have to send little soldiers out to fight and everything and try to take over their city and loot stuff. I think it was that game. And she's playing, and she does not bat an eyelid. Does not look up. I'm standing right there. And I'm shifting around a little bit. I'm probably maybe 3.5 feet away from her because she's sitting right there. She finishes the game, and I forgot to look if she won or lost. I wasn't looking at that moment. But she finishes the game, and she looks up. She goes, Can I help you? And she's all like I just walked in. I'd like to get a haircut, see what the wait time is, and there's two people get a haircut. She's wearing hair cutting attire, and she pulls up the computer and she's looking, and she's like, and this was what, I don't know, 9 a.m. She's like, yeah, the first opening we have is 11:20. I'm like, arguably, I think here we've got an opening right now. But I'm like, you know what? That's not going to work for me. I'm never coming here again. No, I didn't say that. I probably never will because I'm on vacation here. I'll probably never be back. I went somewhere else. Got it cut at a Great Clips, which it was good. It was good. It was a good haircut. All right. I'm not sure why I'm telling you that story. Happy Monday to everybody. Welcome. Hope you had a fantastic weekend. Let me see where we are in chat. We've got the birthday form for all those who have birthdays. Thank you very much. I got my ears lowered. Yes. I look spiffy and dapper. Thank you. I'm not sure if those two words have ever been used in association with me, but thank you. That's cool. Thank you. Congratulations to Tori the Seed Lady, 13 months. That is awesome. Ricky Watson, member for 17 months. Howdy to y'all. Good seeing y'all. Thank you, Ricky. Thank you, my friend. I hear your podcast is going to be back up here shortly, so we can't wait to see that. Richard Chambers, gallery member for 7 months. Spent the weekend reading and my weekly sea swim. Shame it was cloudy, blocking the view of Edinburgh. But glad it's Monday. More court to watch. Yes, it is. It's coming. It's coming. We've got more. Richard, congratulations on 7 months. And Green Eyed Cat gifted a membership this morning. Thank you very much, Green Eyed Cat, for your generosity. I did not see who that went to, but I'm sure they're happy to receive it. Y'all are standing. Hang on. Let me... Hang on. Quit. Lumia Stream is stuck. That's why. Let's do a force quit on it. Force quit. Okay, now it's down. Now we'll bring it back up. We'll give everyone a seat here. Oh man, Crystal H had surgery last week. Haven't been able to join in on the fun. Miss you in the community. Oh, welcome back. Hopefully quick recovery to you, and good to have you here. Thank you so much. We missed you as well. It wasn't the same without you here. Hang on one second. Why is nothing working? Oh, it's over there. It's on the other window. There's updates and such. Let's bring that over here. Okay, I think it should be working now. Are we in a better shape now? Seats are working. Yes, excellent. Commands obviously are not going to work because I left the command computer home. But we do have a buffer here. Rhonda, Wendy by proxy, and Billy all celebrating their birthday today. That means we get to sing to 3 people this morning, which is wonderful. Please join with me, if you will, in singing the birthday song to these wonderful people who deserve it, because today's their special day. So warm up with me, everybody. Deep breath. La 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 la. Excellent. All right, shoulders back. Project your voice to the back of the room. Blend your voice with that of your neighbors. And here we go. Dancers, ready, go. Happy birthday to you. Happy birthday to you. Happy birthday, Rhonda, Wendy, and Proxy. Wendy by proxy and Billy. Happy birthday to you. I wanted to just call you Wendy, and that messed me up for Billy. So, Rhonda, Wendy by proxy, and Billy, congratulations. Happy birthday to you. Hope you have a fantastic birthday. Realize there are a million places you could be, a million people you could be celebrating with, but you have chosen to be here with us. Thank you very much. Thank you. Help yourself to free pancakes at Denny's. Bye, Mrs. R.A. She just for the record, she wasn't singing. I'll take this up with her later, but I clearly saw that during the birthday song she was not singing, and that's not okay. So we'll get that remedied for next time. Happy birthday to Rhonda, Wendy by proxy, and Billy. Hopefully your day is absolutely fantastic, and we can make it even more fantastical. That's a word, right? Fantasticalistic-mish? Something like that. I don't know. Let's see. Yes, I got the update. AJ was born on Friday. Mom and baby doing well. Happy birthday Friday to AJ. The newest addition to the true crime family. Thank you for sharing that information with us. That is awesome. Congratulations. Let's see. Does Mrs. already do homeschool foreign language too? No. We actually don't do foreign language. And I did foreign language in junior high and high school, but it was, I'll say it was a failure because I still barely know how to say my name. 3 years of French, and I couldn't even order bread in France. Drum solo, Jennifer. I'll save it. Here it is. We're going. Here we go. I think it's right here. Is this it? At the ready. There it is. There it is. Big finish. Happy birthday to everyone. Help yourself for free pancakes at Denny's, at all the regular establishments. All right. Melissa P says, same, 3 years of French. I can say like bonjour, comment allez-vous. Just kidding. I can say the basics in a really poor accent, but that's it. And I can say, oh, my little cabbage. That's the only thing. Like, oh, mon petit chouchou. That's all I know. That's all I know. That's 3 years down the drain. All right. Let's see. I was wondering if we were going to follow the case of Jeffrey Piccolo wife, Disney versus dead wife. I have not heard of this one. What's its status? I mean, is this something that's just breaking news? The fresh murdered, blood is not dried type situation? Because that might be a while. But Jeffrey Piccolo. V Disney. Disney tries to dodge wrongful death suit using Disney Plus. Okay, Jeffrey Piccolo's wife died of an allergic reaction after eating at a Disney World restaurant, according to NPR. Disney says his claims must be arbitrated out of court. So a wrongful death suit against Disney. It's in Florida. Interesting. Let's see. Hang on. Disney stores are using a Disney Plus rule to force them into arbitration for wrongful death at a park. Can catch up on Ashley Benefield. I have some reading to do, and I actually would like to do that. Because he had a Disney Plus subscription and that has a rule requiring arbitration, they say that applies. I don't think the court's going to believe that. Krista, the goatee, it fell off. This is actually a younger version of me you're seeing. We just went back in time. Now I'm glad I don't have Disney Plus, because what if I need to sue Disney at one point? It's more entirely likely that they would sue me before I sue them, but it's a novel theory. Lisa Pie, I can look back for your comment. I will try to find it. I've only got a couple hundred to look through. I've got Lisa Logan. Happy birthday. That's what she said. Like that's literally what she said was happy birthday. Sorry, that sounded like a punchline, but no. Lisa Pie, I've gone way back to when the seats started working. I do not see your message. Did you tag me in it? Lisa Logan, Candace. So might as well do a roll call while I'm scrolling through here. Got a lot of people. Lois. Ivy, Luna, Oatmeal, Lois, Out and About with Diane, Crunchy Frog, Nikki, Karen, Ashley, Gretchen, Melissa. I see this one that says yes. I cannot find it. Can you type it again? I apologize. I'm looking, but I just don't see the comment. You tagged me in it, so it should be easy to jump out at me. But it must have been. I can only store about 100 comments on my screen before it starts flushing the old ones out, and I can't scroll back any further. So I missed it. I am still on the road. We're still in northern Utah right now. A couple more weeks before we head up to Idaho. The lawsuit response also says the couple signed the liability waiver when they signed up for the park experience, which is better, but trying to get this Disney Plus nonsense included. The liability waiver is probably much more applicable in this case, just my gut feel. Disney scheduled for October. I wonder if they're going to fight against the media being there. I'm a real boy. Sample user, welcome. Adam, good to have you here. I missed a bad joke. I apologize. Sometimes I skip over things, don't mean to. Liability for food. This is a tough one. It's a tough one. I don't know where I stand on that, like personally, because I realize there are some people who are deathly, allergic to peanuts, for instance. And there's a place I go regularly that has a sign up that says, "Hey, don't even bring your kids snacks, like a trail mix here, because just it being in the same building is going to kill this lady." And that's a pretty severe reaction, obviously. But food. We're going to be in the Boise area. Boise Meridian. I don't know where our Airbnb is yet. I've never seen it. This morning, a guy on X in France is live tweeting about two guys who are metal detecting on his property and the drama of making them leave. They're making Sov-sit type claims. It's hilarious. Oh my goodness. Metal detectors trespassing to detect? This is a big no-no. This makes the entire hobby look so bad. In France. And I don't know the rules in France, but I'm pretty sure private property is private property pretty much almost anywhere. Ray Mantle, I went on vacation. That's the only interesting thing that's happened. We're following a really cool case right now with Robert Tellis out of Las Vegas. He's a public administrator, elected official, or was. He was responsible for if somebody died and owned property, like a home in the Las Vegas city, in that area, and they didn't have a will, the city decides what happens there. And he was involved in the process of taking those houses, literally, that somebody owns, and fixing them up and selling them, and then giving some of the money back to the descendants. That was his gig. It turns out that his office was a little bit hostile, according to some, and when a investigative journalist started doing stories about it, did 4 stories, was about to do a 5th, and had one in the works, had just requested a boatload of documents, emails, text messages, everything else from Robert Tellis and a couple other people. And next day he was found stabbed to death in his yard by someone who looked very similar, or at least was driving the same vehicle as Robert Tellis, and possibly been the same height and stature. Have the same gait, same walk. And, there's the small fact that the victim's fingernails, underneath the victim's fingernails, they found the DNA of the defendant. And in the defendant's house, when they searched it, they found the bloody shoes, the parts of the outfit that was worn by the assailant, all cut up and hidden. Little things that just add to the evidence pile. Oh no, Melody. Lightning struck a tree next to the house. Now my oven is broken. My washer too. My last my oven went. Oh. Melody, I am sorry. I am sorry. That is no fun whatsoever. Prayers for you for sure. That's terrible. Hopefully everything it's worked out here, especially with your husband's health. I think that's going to be a lot of times things are easier to replace. People, not so much. Not so much. All right, let's see. Oh, we were going to do some court hopping. Let me. Update. Robert King. We talked about him. Or no, Kenneth King. Excuse me. Mixing the court case and the judge. We talked about Kenneth King. He was the judge that threw a teenager in prison who was on his field trip to his courtroom and fell asleep in court, or threw her in jail, locked her up, cuffed her, whatever else. He's been relieved of his teaching position now at the college, and he's also still on leave, and so I'm not sure if he's coming back, honestly, to tell you the truth. Let's jump into a court where it looks like some things are happening, and yes, you'll see some familiar faces here. I see Judge Webster.
Uncertainty of the circumstances.
Right. Thank you, Your Honor.
You're welcome. We'll now be on the record in 2022 TR 3421, State of Kansas versus Joshua Kane Marsh. Please announce appearances.
Jared Regier on behalf of the state.
Good morning, Your Honor. Rocky Wedgman on behalf of Joshua Marsh, who also appears behind me.
Way back there in the back row.
And how does your client wish to proceed on this fifth control hearing and addressing speed and driving while suspended, second or subsequent?
We just like to set it for trial, Your Honor.
Bench trial or jury trial?
I'm sorry?
Bench trial or jury trial?
A bench trial, please.
All right, bench trial will be set. And Jen, when is our next bench trial?
We're waiting.
I know it'll be on a Wednesday at 1:30, but Jen, if you could tell me which Wednesday?
Sorry, I was muted. September 25th at 1:30.
September 25th at 1:30. Does that work with both counsel?
Your Honor, I have a preliminary hearing going that day at 1:30 in Sedgwick County.
All right, we'll try another day then.
Give me just 1 second.
Sure.
Ray, that's terrible.
Looks like October 16th would be the closest.
October 16th at 1:30.
A lot of history in Ireland. A lot of history just rusting under the ground.
October 16th at 1:30, correct?
Yes, correct.
Okay. Thank you.
All right. Mr. Marsh, any reason why you can't be here that time?
I'm sorry, what was that?
Is there any reason why you can't be here October 16th at 1:30 for trial?
Yes.
No.
And is that a trial as Zoom or is that in person, Your Honor?
It's Zoom.
Okay, thank you.
All right, that is the order then. Bench trial October 16th at 1:30. Mr. Marsh's bond includes all prior conditions and the added condition that he appear at that date and time ready for bench trial. There's nothing else. We'll be in recess, and counsel and client are excused unless, counsel, you have anything else on the docket?
I do not, Your Honor. Thank you.
Thank you. We'll now be on the record in Martinez, 2024 CR 95, State of Kansas versus Michael John Martinez. Please announce appearances.
Jared Regier on behalf of the state.
Chris O'Hare appears on behalf of Michael Martinez, who's also present, Your Honor.
And this is the third controlling on battery of a law enforcement officer in both counts 1 and 2,
Ooh, that's a bad
interference with law enforcement in count 3, disorderly conduct 4, firearms while driving under the influence, or driving under the influence. Count 5, count 6 battery, count 7 pedestrian under influence. How does your client wish to proceed on this third control hearing, counsel?
Your Honor, I've spoken to my client also, Ms. Norris, and I think we want to just set it for trial.
Bench trial or jury trial?
Jury trial, Your Honor.
Our next jury trial setting is October 2nd through 3rd at 9 a.m. each day. That will be live and in person, but we will have a prior pretrial. The pretrial will be September 30th, 9 a.m.
Your Honor?
Yes.
Sorry, is it possible, Ms. Norris and I spoke about that, is it possible to get, she said you might have a February setting. Is it possible to have that?
February?
Well, I hate to set it over that
is
far.
way back.
Of course, September's right around the corner. That'll put it, this allegedly happened March 2nd, so that'll put it close to a 1-year anniversary.
Check.
I'm going to put it on this docket, and then when that comes, it's going to be a docket, so maybe we have to continue it anyway.
Okay.
So September 30th, 9 a.m. will be the pretrial. That will be by Zoom. If any way you could work it out or decide if you actually need the trial. It sounds like one I could give priority to in light of the charges. All right, so Mr. Martinez, your bond is continued with all existing conditions, plus the added condition that you reappear by Zoom for pretrial September 30th at 9 a.m. And then your jury trial is set 9 a.m. October 2nd and 3rd live at the courthouse. And if anything further, counsel, either party?
No, Your Honor, thank you.
You're welcome. Mr. Regier, anything?
I never saw the client.
Your Honor, if assuming that counsel for the defense will be filing a formal written request for a jury trial as required by statute, I do not
have, Your Honor.
Your Honor.
All right. Very well.
Wow. Interrupted him.
All right, we'll be in recess at this time.
He has a help wanted sign up in his
And counsel
over his
and
shoulder.
his client are excused unless there's anything further.
Maybe it's Sarah Boone's advertisement.
Let the defense say, Your Honor.
No, thank you, Your Honor.
Thank you, Mr. O'Hara. You're excused along with your client. We'll now be on the record in Sawyer 2023 FG3 00002.
Thank you,
State of
Greeners.
Kansas,
5
Ballot
membership.
versus Dallas, Kervin Sawyer. Please announce appearances.
Jeb Regier on behalf of the state.
Peter Hagan for Dallas Sawyer, who appears next to me.
And this is his third control on voting under the influence. How does he wish to proceed, Mr. Hagan?
Well, Your Honor, we've been waiting for blood tests on this case, and that's why the state has continued it. And I don't. Last time we were here, Mr. Regier wasn't present. I don't remember which DA was here for him, but they said they had him, and then they didn't send anything. So we called the office, and they said, we've already sent everything we have to you. You'd have to do another request or something. And so anyway, I don't have blood tests, and I've been waiting for them.
Well, County Attorney Darren DeVinny, the county attorney, looks like he was here in June and would have told you, it looks like he did tell you that they would get you the requested information. It seems odd I know the lab is incredibly slow, but these charges reportedly date back to August 19th of 23. I don't think I've ever known him to take a full year. This is the 1-year anniversary of the charges. Mr. Regier, is that your office's position that there are no blood tests?
One moment, Your Honor.
Or is it your position that they're still waiting in the lab?
I know it's been a year. Dismiss the charges. This is a fishing while drunk charge, or what they like to call boating under the influence. Chad's here now. Welcome, Chad, on your iPhone.
Your Honor, in accordance with my duty of candor as an officer of the court, I am showing a KBI lab report in this matter.
Mr. Hagan, you've not received it to the best of your knowledge?
I have not received it, Your Honor, and have requested it several times.
Yes, and the county attorney himself told you he'd get that to you. So, Mr. Hagan, your proposal at this time?
Move to dismiss.
Well, I'd like to set it over so I can get those copies, Your Honor, or the testing.
All right. Well, I'll set it over one more time, but I may just have to set it for trial, and then they can either, if they haven't given that to you, we may not be able to include. So, Mr. Regier, Mr. Hagan, I hope this is our last continuance. Like I said, today's its anniversary.
Yeah, he missed
Jim,
an
what
opportunity.
date do you
Move to
have?
dismiss.
Are you wanting bench trial or control?
Control,
That would be November 4th.
November 4th. And Mr. Hagan, maybe you need to make a call directly to
What's the
county
yawn
attorney.
counter up to?
I did last time, Your Honor.
Oh, okay.
After you ordered them to give them to me and I didn't get them, we called the office and requested it again.
Well, I sure wouldn't want to find the county attorney in contempt, but yes, we have addressed that. All right. Thank you, counsel. We'll be in recess till November 4th at 9 by Zoom again. Mr. Sawyer, you're continued on your bond. Same conditions. No alcohol. I'm sorry, Mr. Sawyer. No alcohol, no illegal drugs, no driving under the influence. You are excused, Mr. Sawyer. Mr. Hagan, you're excused unless there's anything further.
No, thank you, Your Honor. Appreciate it.
You're welcome. All right, we are now on the record in 2024 CR 231, State of Kansas versus Coral Lee Shannon. Please announce appearances.
There's Coralie.
Here on behalf of the state.
Joshua Andrews on behalf of Ms. Shannon, who is also present.
Mr. Andrews, how does your client wish to proceed on this one count of marijuana at her first control hearing?
Your Honor, I was appointed on July 30th. I received the discovery a week or two ago, but I've not yet had the opportunity to review it. So I'm requesting a brief continuance. I don't think I need more than 30 days to review the discovery and then discuss the case with my client, see how she wants to proceed.
Well, I wish I could give you a brief continuance, but how does November 4th at 9 look?
All right. Yes, that works for me, Your Honor, and that should be more than enough time.
Let me write it down really fast, okay?
Okay. Jen, is that what looks right to you, November 4th?
Yes, the others are pretty full.
All right, thank you.
At what time, ma'am? What time?
9 a.m. You need to be back here by Zoom at 9 a.m. Mr. Regier, I would give you the opportunity to voice any additional comments or objections you might have.
Your Honor, if it is the court's order that this matter be continued to November 4th at 9, I do not believe I have any objections at this time. This does appear to be the first control hearing after the original first appearance date before Judge Rickey back in June. It would appear that the court at the previous hearing did appoint Mr. Patterson and did make certain orders concerning bond. I do appear to have a copy of that same bond in my file. It does appear to include all standard conditions, including, quote, the defendant will refrain from violating any laws of the United States. The state would be requesting perhaps a point of clarification from the court as to whether that would include contact with controlled substances at this time.
Ms. Shannon, I am making it clear as a condition of your bond that you not have any alcohol or illegal substances, including but not limited to marijuana, as long as this case is pending.
No way, no how. I do have a prescription, but it is through my doctor, but no marijuana, no alcohol, no illegal drugs, nothing like that.
Right. If it's a legal prescription from your doctor, unless it's marijuana from Colorado or Missouri or someplace, that's not legal federally.
No.
It's not legal in Kansas, so you can't go do that. You can't go out.
No.
Okay. All right. Sounds like we're clear. So you're continued on your bond, and you are excused at this time, Miss Shannon and Mr. Andrews. Do you have anyone else on this docket?
Not to my knowledge, Your Honor.
Thank you. Then you and your client are excused, and will now be on the record in Sutter. Case number 2024 TR 1661, State of Kansas versus Caleb Lee Sutter. Please announce appearances.
Jared Regier on behalf of the state.
Bill Cummings appears on behalf of Caleb Suter, who appears in person.
Okay, thank you. And this is Mr. Suter's first control on a DUI. How does he wish to proceed?
Well, we'd like to proceed, Your Honor, but we've not received any videos from the county attorney's office. I confirmed that this morning that they have not received it from the Highway Patrol, so we're really at a sticky point. The videos do exist, they just haven't been provided.
All right. Well, I'm going to probably have to set this over to November 4th, is it, Jen?
That's correct, Judge.
November 4th at 9 a.m. Mr. Regier, I don't think you filed the DUIs. Whether you do or not, can you please make sure that he gets what he needs as soon as he can get it for his discovery?
Your Honor, in reviewing the information filed in this court, it would appear that this case was initially filed by my colleague, Ms. Cheryl Pierce. I will be sure to put a note in the file.
Thank you. I appreciate that. Nothing further then. Defendant, again, you're continued on that bond. No alcohol, no illegal drugs, no open containers, nothing to do with that substance and all existing conditions.
What
We'll
is
be
it
in
with
recess.
Kansas?
Counsel and client are excused at
discovery
this
turned
time.
over.
And Your Honor, that was November 4th for the next hearing date. Forgive me.
Yes, November 4th, 9 a.m.
Did Chad put on a suit coat?
You're welcome.
I didn't see a suit coat before.
And Chad's iPhone, what is your name?
Chad. Wait for it.
Chad Stanball. Darren Patterson's my attorney.
All right. Well, we'll have to wait just a bit for him. Thank you, sir.
Yes, Your Honor.
Any other defense counsel here today?
We've got a couple clients, but no defense.
The lady at the county jail. I'm sorry, I didn't see you were there until later in my docket. What's your name, please?
Kathleen Hutton.
Miss Hutton, is your attorney Darren Patterson?
Yes, ma'am.
Have you spoken to him this morning?
Yes, ma'am.
Jen, do you know if we could get him out here for a bit?
Yes, he is currently in a breakout room with Mr. Canfield.
All right. Well, we'll get him out here as soon as we can. Deputy there at the Butler County Detention, how many other folks do you have there waiting for court?
This is it, Your Honor.
Okay. So if you want to send Jen, if you want to send Mr. Patterson a note that we have someone at the jail waiting, you might be able to get out of that for a minute.
Whoa,
And
detective
let's see. It looks like I'm
people
looking for a
Kentucky
Miles
courthouse this
Dorsey Yahtzee Bassett Jr. Is that individual here?
Yahtzee Bassett.
I'm right here.
All right. So if you could just kind of stay still with your camera, that would help me. Thank you.
It's hard
And you
because
do
I'm
not
driving,
have
Your Honor.
counsel. Is that right, Mr. Bassett?
No, Your Honor. I was gonna try to secure counsel, but
excuse me, sir. Let's go on the record. We're on the record now in 2024 CR 188, State of Kansas versus Miles Dorsey Yahtzee Bassett Jr. Jared Regier appearing for the state, the defendant appearing in person and pro se on possession of hallucinogenic drug.
Shrooms or LSD.
Or psilocybin, and count 2, paraphernalia.
Shrooms, right?
You told us back on June 21st you were going to hire an attorney. Now, what were you wanting to tell me about that?
I was gonna just say I was not able to secure counsel, so I was gonna just ask or request for a court appointed.
Very well. Now, it looks like you're in a truck. Are you employed?
Yes, ma'am. I'm at work at the moment.
What kind of work do you do?
Would say assembly. It's a little bit of assembly and factory work, warehouse.
All right. And what do they pay you per month to do that?
$14.50 at the moment.
$14.50. And do you pay any rent, mortgage?
Yes, ma'am. I have an insurance bill, and I do pay a little bit in rent.
What's the little bit in rent that you pay?
At the moment, just $250 plus $150 for the insurance.
What kind of insurance is that? Is that automobile or house, rent?
Yes, automobile, Your Honor.
Do you pay anything for the utilities at your residence?
No, I do not.
It's got to be living with
You don't have
family.
any other bills?
Not in my name, no.
Okay, now I don't know what that means. Does that mean you are paying other bills?
Yes, but they're just like my phone bill isn't in my name.
All right, well, what do you pay for your phone bill even though it's not in your name?
It'd be $115 every month.
But you do pay that yourself?
Yes, ma'am.
All right. And what else?
Other than just groceries at the moment, nothing but gas.
Those are two of the most expensive things, I think, right now, groceries and gas.
Yes, Your Honor, especially
All
in
right.
the truck.
I will find that you qualify for court-appointed attorney. I didn't even ask you if you were married or had children, but that would only make you more so eligible. I will appoint Attorney Darren Patterson. Are you ready to write down his number?
Yes, ma'am, go ahead.
It's Darren, D-A-R-R-E-N, Patterson, traditional spelling, P-A-T-T-E-R-S-O-N. And his number is
867-5309.
Now, I'm going to order that you call his office as soon as you leave this hearing and give them your contact number and your court date, which, Jen, is it November 4th still?
Yes, it is.
All right, sir, you need to be back here November 4th by Zoom, but at 8 a.m. to talk to Mr. Patterson. Now, if you can talk to him before then, that would be better. But you make sure you're here at least November 4th at 8 a.m. Your bond requires you to have no alcohol, no illegal drugs, don't violate any laws, and all other conditions on that document. Mr. Regier, anything else we need to address on Mr. Bassett?
From the state's perspective, Your Honor.
All right. Anything further, Mr. Bassett, that you need me to cover?
No, Your Honor.
All right. Then we're in recess and you may go. Call Mr. Patterson. Okay. Thank you. You too. We'll now take up Gilkey on the record in 2023 TR 897. State of Kansas versus Jamar Gilkey. Jared Regier for the state. Is Jamar Gilkey here?
Bench
Jamar
warrant.
Gilkey fails to appear. Are there any bondsmen for Jamar Gilkey?
Guilty is guilty. Yes, Greeners. You made the joke.
We are set today for motion for judgment on a $500 bond that was posted November 9th, 2023 for a registration matter. Mr. Regier, concerning service of process, what have you to say?
Your Honor, it would appear that in this matter, a motion for judgment on bond was filed with the court on April 19th of 2024. It does appear to include a notice of hearing both to the defendant as well as to an agent for a certain bonding company with an original hearing date of July 1st of 2024 at 9 a.m. The state's understanding is that at least as of last week, August 13th, which is admittedly somewhat dated. There has not been a return of service on the original motion for judgment on bond filed with the court. However, I am showing that a notice of hearing was more recently filed with the court. It does appear to include an attached, at least page 1, which would appear to encompass the motion for judgment on bond. It does also appear to include a certificate of service indicating that on the 7th day of June 2024, a June copy of the above and foregoing notice of hearing was forwarded in the U.S. mail. It appears to list both the defendant and the agent for the bonding company. So under those circumstances, the state would respectfully defer to the court as to how it wishes to proceed, while also noting that the notice of hearing does appear to include both today's date and time, August 19, 2024 at 9 a.m., as well as a meeting ID and passcode for accessing the same.
At this time, I will grant judgment on the bond against both defendant Gilkey and Green Feather Bail Bonds.
Green Feather.
Agent LaShawn Davis. Due to the defendant's failure to appear, that as ordered on February 28, 2024, the $500 bond is ordered forfeited.
Very good, Your Honor. And
Ouch.
For purposes of the record, although this may or may not change the court's order, I am not showing that there was a hearing in this matter on the original date of the motion for judgment on bond, again, July 1st of 2024, although, again, there is the notice of hearing for today's date and time, which was previously filed with the court as previously indicated.
Showing June 7th, 23, the
Eric,
defendant failed to appear, and that's when the $500 bench warrant was issued. I'm showing February 28, 24, the defendant did fail to appear, a new bond was set. And
I've
you're
got to talk
saying
to you
this
about
was
this, Eric.
originally
I read
set
that
for
and I'm like,
July?
I need the scoop.
The motion for judgment on bond does appear to include a July 1st, 2024 date on the notice of hearing, but I do not have any notes from a hearing on that particular date. But again, the notice of hearing does refer to today's date and time.
And for that reason, I do grant the judgment.
Very good, Your Honor.
We will now be on the record in 24 TR 233, State of Kansas versus Ashley Jordan Jones. Jared Regier for the state. Is Ashley Jordan Jones
If she's not here while they work
or any bonds person for her?
They're not, so they're going to do the same thing.
This is a motion for judgment.
I'm gonna turn off the sound here for a bit. Eric, stop me if I'm saying too much. There's a court case going on that might have an element of how do I say this? Sweeney Todd involved with unknowing members of the public. And that portion of the case might be being kept very quiet so that people don't know that they unwittingly ordered a people pie. Is that vague enough, but still enough detail? Yeah. Okay, so that's as far, and right now there's suspicions, there's questions, there's allegations. It's very, very quiet, and when we don't know if it's true or if it's just a rumor. But it's bizarre enough that it sounds like it might be true. So we'll have to get some more information. I can't tell you what the court case is or anything else because we don't want to link that with anything else. But not even going to say what state it's in. Anything else? Melissa says, "I want to thank you. I was hungry." Okay, we're gonna do some more digging. We're gonna do some more digging, and
$1,500.
we might cover that
due to the defendant's failure to appear.
I can either confirm nor deny.
Hearing noted in
Eric,
the motion.
I want to talk to you about it.
And today, and as for the bondsman not appearing today, so
Very good, Your Honor.
You guys, the comments here are great.
Recess on that matter.
Oh my goodness. It sounds juicy, says Martha. Oh.
Let's take up step on the record in 2024 TR 999, State of Kansas versus Zachary Schuyler Scott Stepp. Jared Regier for the state. Is the defendant Zachary Schuyler Scott Stepp present?
In just a minute, it's just going to be
Yes,
Judge
Your
Webster,
Thank you. And
Jay
you do not have an
Regier,
attorney
and
today,
this
is
lady
that correct?
in the jail.
Well, I was supposed to be appointed Patterson, but for some reason there must have been a miscommunication with the court and him, because when I called, he said that they had dropped my case.
All right, well.
Well, they
June
called the case, so it
17th,
hasn't been
and there
dropped.
was a curious entry in the file, and maybe Mr. Regier can clear this up for us. The June 17th, 2024 docket note is the only note in this file, but it says this case was filed first as BU CR or 24 CR 144, then dismissed to make it a traffic case.
You guys are
And the
terrible.
first appearance on this
I love
case
it.
was before Judge. First appearance was before Judge Hart on the other case. The defendant is to get booked and printed. Bond is 1,500 OR and set over for today. So, can you help us figure out what that all is telling us about these two cases, Mr. Regier?
One moment, Your Honor.
The thing I like about Regier, he sits there
Your
and
Honor,
thinks about
as
it,
a
and then has all the
preliminary
details.
matter, it would appear that Mr. Patterson was appointed previously at the June 17th hearing.
Excuse me, and was that on this case, or was it the 24 CR 144 that was dismissed?
Your Honor, the state's understanding is that a journal entry of dismissal without prejudice was filed in the CR case prior to that hearing date back in April. So.
Okay. And so then on this case, Mr. Patterson was appointed. I'm not seeing that, but that doesn't mean that it didn't just get omitted.
That's what my notes would appear to reflect, Your Honor. I certainly do have certain hesitancy proceeding too far without counsel for the defense present based off of my notes in my file.
Well, my notes in my file show he's pro se and no mention of Patterson or appointment. So.
Your Honor, if I may.
Yes, Mr. Canfield joining us from the county attorney.
Thank you. I did speak with Mr. Patterson about this case. He has not received an order appointing counsel. My notes from the last hearing do show that the court had appointed Mr. Patterson, but that is as far as that process has gotten.
Don, welcome to the gallery.
All right. Well,
it's at least
he
month
wasn't
3 for you.
appointed
Thank
because
you
I
so
didn't
much.
have it in the notes. So I don't know how we overlooked that. But Jen, if you would please make a note that Patterson is appointed, and why don't you put on there per counsel, Patterson was appointed on such and such day. What was that, June?
June 17th, Your Honor.
Per counsel and the defendant, Patterson was appointed June that date. So let's appoint him now and get an appointment to him. And in the meantime, Mr. Stepp, I think we're going to have to set this over.
Patricia, thank you very much. Congratulations on 2 months. Court security wants to talk.
Yes.
He was supposed to come to the courthouse and sign a bond and then be sent out for processing, and he hasn't done that.
Mr. Stepp, why didn't you do that?
I was already remanded and signed a bond. That's how I got out in the first place.
Okay, I can see where you're confused because I've been confused. But what I understand is you were charged under a criminal case and you bonded on that criminal case, but they dismissed that criminal case and then they refiled it as a traffic case. And at the first appearance on the traffic case, You are ordered to go out and get bonded for the traffic case.
Okay, well, I must have misunderstood because I didn't know that. I thought that when I signed it the first time that I had already signed it.
Yeah, that's what it sounds like. It sounds like it was just confusing. So I'm going to make you go into breakout with security 2 here in a minute, but this time they're going to give you a date and you must go do it or you're going to be in trouble with the court.
Okay.
But I understand any confusion you may have had previously. So your bond will still be $1,500 OR, but you get with court security 2 here in a minute and get that squared away. Now, Mr. Patterson, for whatever reason, my notes don't show he was appointed, so no one appointed him from the court. But we're taking care of that now. He'll get the appointment, and then he can get the discovery, and you can
it's
contact
nice of Mr. Patterson
him.
to join us, but security's
I'm going to order that you
tag
contact him
teaming.
again.
Got
Mr. Patterson, you're
two
not on
security
the
here.
case officially yet, but you're kind of hearing some of this. Do you want any other instructions for him? Do you want him to call at a certain time?
Judge, what I would ask for is that when he finishes with everything with court security, that he then call my office to give us all his contact information. Even if he's done it before, we'd like to have him do it again today.
All right. Mr. Stepp, do you understand that?
Yes, Your Honor.
It's just they filed it as a criminal case. That's one case and it's over. But now it's a new case. We start over as a traffic. All right,
Okay.
so you call his office. I'm ordering you to call his office. You still have his number?
Yeah.
322-7700. Okay, and your court date? November 4th, Jen? That's correct.
Trial starts in about 2 hours for the Robert Tellis trial.
At 8 a.m. November 4th, sir.
We have another thumbnail
All
up
right,
ready for that to begin.
Sorry about that. I don't know what happened with the...
Well, like I said, I understand.
We know. You messed up.
You're okay.
Just own up. You're
Anything
good.
else we need to address? He is continued on that bond once he posts it.
Nothing further, Your Honor.
I think we're going to go to the jail to defend it
Mr.
now.
Stepp, go into breakout room with court security 2. Jen, if you please put Mr. Stepp and court security 2 in a breakout room. And Mr. Patterson, there was a lady at the jail. I don't see her now. Did we get that resolved?
She's on there, Judge, and that...
Oh, there she is. Okay.
That's Kathleen Hutton.
Yes.
Mr. Stepp still hasn't made the jump to... oh, there he goes. Okay. Kathleen Hutton, I'm sure that's not the jail law library.
On the record in 2020, TR 3100, State
those
of
are real
Kansas
books.
versus
That's not a
Kathleen
backdrop.
Ann Hutton. Please announce appearances.
Look at the dust on
Your
the
Honor,
shelves.
state appears by Devin Canfield.
Your Honor, Darren Patterson appear on behalf of Kathleen Hutton. Ms. Hutton does appear from the Butler County Jail. Your Honor, in this case, it was initially heard by Judge Lee last Friday. Judge Lee did take a plea on the amended information to count 1, driving while suspended as a second-time offender. The state had dismissed count 2 as we were proceeding through sentencing. Judge Lee was concerned that there was a medical problem or medical issue, did not want to finish sentencing at that time, set it over for today for sentencing. I would tell the court I've met and talked with Ms. Hutton here this morning. She does not have the issues she had last week, but she is very coherent, ready to proceed. I believe that we can accomplish sentencing here today.
Sounds like we should have watched last week.
All right. Recommendations for sentencing, Mr. Canfield?
Your Honor, the state would recommend a fine of $100, an 8-month underlying, suspended for a 12-month non-reporting probation. And there is the 5-day minimum. I would ask that the court grant jail time
She's got
credit.
me on him.
My understanding in speaking to Mr. Patterson is that will satisfy that 5 days.
All right. Mr. Patterson, anything further?
The only thing is last Friday, the agreement was for a 6-month controlling sentence by plea negotiations.
And Your Honor, if if the court wishes, I was the prosecutor on the last hearing.
Jared Regier joining us for the state. Mr. Regier, go ahead.
Regier and Canfield do a
the
double
state's
appearance.
understanding is that previously there had been an agreement reached on the issue of disposition, $100 fine, court costs while deferring to the court on the issue of attorney's fees, 5 days jail with credit for time served, as this is a Class A misdemeanor. 6 months underlying sentence, 12 months reporting probation, $6 probation fee with all standard conditions. The state does not have an objection to proceeding in that fashion. If indeed the court is comfortable proceeding to sentencing, the state's understanding is that there were certain concerns raised by the court at the last hearing, although I think Patterson, or rather Mr. Patterson, has already addressed those far better than I can.
All right. And Ms. Hutton, what kind of work do you do?
Currently I am unemployed, but I have a very good work history. Normally at Quick Trip was my last job for 5 years, and bartending before that for 10 years.
Why are you not employed right now?
Because I'm in the jail.
Because I have a ride issue. I did, but yeah, I just need to go fill out some applications. It's really easy for me to get a job.
Okay.
I can get a job very quickly.
Well, since you don't have a job right now and you've been in custody for how long?
Judge went into custody August 13th.
Okay. I'll go ahead and waive your attorney fees, but your fine will be $100 and your court costs will be $108. So you owe $208. Can you get that paid in 60 days, do you think?
Yes, ma'am.
All right, 60 days to pay. And your controlling sentence is 6 months. If you don't want to spend the balance of the 6 months in jail, then you need to be successful on non-reporting probation for 6 months. During that 6 months, you won't.
Judge, as an officer of the court, I just want the court to know the plea bargain was for reporting, but of course we'll leave it to the court how the court wants to do the sentencing.
And Your Honor, the state's understanding is that it was a 12-month reporting probation is what was previously agreed to as a part of plea negotiations. One thing I might also add, although this may or may not have any bearing on purposes of sentencing here today, is that the state did address on the record at the last hearing the possibility of KSA 223210 concerning withdrawal of plea occurring or at least applying in this matter. However, the court did decline to enter orders setting aside the plea, notwithstanding that count one, that based off my notes, guilty plea to count one was entered in exchange for a dismissal of count two.
Okay. Any reason to set aside the plea, Mr. Patterson?
We're not raising any issues concerning setting aside a plea, Your Honor. We're asking the court to complete the sentencing here today.
Okay, now, Mr. Patterson, you thought it was 6 months non-reporting. He says 12 months non-reporting.
No, Judge, I said
reporting.
6 month sentence. The plea bargain was for 1 year reporting.
Oh, okay.
And I wanted to be honest with the court about that.
All right, thank you. All right, I think I've got what the agreement and recommendation is. So your sentence is for 6 months in the county jail. And if you don't want to finish off the 6 months in jail, you need to report to probation for 1 year. And you have to do everything they tell you to do. It's going to be very important that you go to see them or you call them, whatever they tell you. They're going to give you a list of standard conditions, and you're going to have to follow those. You also have to pay. Now, with supervision, that's going to make it $268. Will 60 days still be enough for you to pay the $268?
Yes, ma'am.
All right. So $60 supervision fee added to that is $268 to be paid within 60 days. That's a condition of your probation. And I can't emphasize enough how important it is you report. And you don't change jobs, you don't change residence, phone number, anything without them knowing what you're changing it to before you change it.
Yes, ma'am.
You can make this as easy for yourself as you want by doing everything you want and getting it closed, or you can drag it out and make it a nightmare and end up in jail for 6 months. The other thing is there is the mandatory 5 days jail, and I give you credit for any time you've already served. If that only comes out to 4 days, you'll still have another day to serve. But if you've served 5, then you're done with that.
Yes, ma'am.
So anything else we need to address?
No, Your Honor.
If the court is ordering reporting probation be subject to all standard conditions, the state has nothing further, Your Honor.
All right, I am ordering all standard conditions. One other condition, Ms. Hutton, you must contact court services as soon as you're released from jail.
Zachary Wells, thanks for gifting 5 memberships. Appreciate it, my friend. Very generous.
And the jail probably has their phone number to share with you, which is 316-322-4153. But your first communication once you're released is court services, or you'll be in violation right off the get-go. Okay?
Yes, ma'am.
All right, nothing further. We'll be at recess on Hutton. Ms. Hutton is excused.
Thank you, Your Honor.
James Young, Jim Baker, still up.
Okay.
I think they're probably both
Mr. Patterson,
Pattersons.
James Young is still sitting there. Do you want to take up his case? Have you had a chance to talk to him?
Judge, I attempted to. We never have had the opportunity to talk. I have certain people that I have been able to talk to and get ready for, certain I haven't.
Okay.
I can call the ones out, Judge, that I'm ready on.
All right. Well, before you do, James Young, can you hear us? Okay. All right. Why don't you click on that little red microphone just so I know that we're good? Do you see that little red microphone?
Yes. Yeah, I unmuted now.
All right. Now you've got it.
And yes, I've been able to hear everything.
Yeah.
We've been able to hear you too.
Mute and wait, Mr. Patterson will be with you after I cover a few of these cases. Thank you. Mr. Patterson, do you have any special order? Well, let's see who's in the courthouse.
I thought she was wearing a striped jail outfit.
Court security, do you have anyone you want us to take up?
I have 2 people, but I don't believe that Mr. Patterson has visited with them yet.
Judge, on John Roberts, I am ready on that one. We can take that up immediately.
All right,
Heather's
let's
about
get
to drive.
Sean Roberts out here.
Heather has just gotten in the car, key in hand, ready to fire up the ignition.
All right, we are on the record in 2024 CR 167, State of Kansas versus John Allen Roberts. Please announce appearances.
Your Honor, state appears by Devin Canfield.
Your Honor, Darren Patterson, here on behalf of John Roberts. Mr. Roberts says appear from Court Security 1 video station. Judge, we'd ask to have this case set for a jury trial.
Jury trial, next setting is that September 30th pre-trial at 9 a.m. and jury trial October 2nd and 3rd, 9 a.m. at the courthouse. Mr. Roberts, I'm going to continue your bond, but you are set to be here by Zoom Monday, September 30th at 9 a.m. and then again for jury trial live October 2nd and 3rd at 9 a.m. unless told otherwise. All conditions of your bond will continue. Anything further, counsel?
Jim Baker just covered his camera.
All right.
Well, Mr. Patterson, will you be in your office later today?
I'm not available today because of my court hearings, but we'll get a hold of you or call in and we can set something for you.
Okay, I was still under the assumption that this was going to be an extension.
We'll set it there and we'll get it worked. We'll get a hold of you.
Just be patient. Mr. Patterson sounds like he has it under control. He just can't talk to you today because he's got too many court appearances today.
Yes, ma'am.
Okay. All right. Thank
He
you,
has too
sir.
many
You're
appearances because we
excused.
keep assigning him new cases.
The other
like crazy.
one at the courthouse, Your Honor, is Theron Von Trost. I need a breakout room with him, but I also need to email to counsel and the court a drug and alcohol evaluation.
All right. Let's go ahead and do that. And is that V?
V is in Victor, Von Trost.
Okay. Thank you. I see that.
Do I send that to court security 1 or 2?
2, please.
It's just Judge Webster and us.
And Your Honor,
Yes, sir.
taking advantage of the momentary lull, my understanding is I do not have any additional cases on today's docket. I will respectfully withdraw with the court's leave and defer to my colleague, Mr. Canfield, for the remainder of the morning.
That would be fine. Thank you.
Thank you, Your Honor.
You're welcome.
I love how even he is. He reminds me of Data. Now's your chance to talk to the judge, James. No one will stop you. Mel Siller, thanks for the kind words. Hello to our good friends up in Canada. Mr. Opatroso, this was probably one of the funniest witness testimony I've ever seen in a case. He was awesome. He did not want to be there though. So you're good. We might jump over to Judge Boyd. It's gotten a little quiet here. So all right. Judge Boyd. Wait, how'd I end up? How'd I end up on Chancery?
I can see everyone, but I still can't see myself. And then showing the light, saying my camera's on, but I don't see myself.
Judge, you're muted.
Yes, sir. And Judge, so September 16th.
The judge is muted. This was a criminal. It was a criminal docket, which is always fun. But if the judge is muted, we've got to instead jump to Judge Boyd. Good morning, Judge Boyd. You see, you've got the red purse this morning. Fine choice. Look at that epic picture of a previous judge up on the wall. I think she's already called roll this morning. As always, court in Judge Boyd's courtroom starts slowly and then ramps up, and then it's always busy at the end of the day. Katrina, hello to California. I'm not far away. I'm in Utah right now. Yes, we did hear about the family that was doing the DNA. I think they've got one more hearing scheduled. Let me see if I put it on the chart here.
No, those bad news. You guys see.
I don't remember what the date was for it. I can't see it on my chart. But what happened on that case was they did all the testing, and there's a possibility that she's related. And so now they have to do more testing.
Darren Doe's.
Or expert analysis to see if she is actually a relative. The two sides looked at the results
We still have
disputed what
a
it
jury
meant.
deliberating, so we can't go on trial in this case. All right, Miss. How long do y'all expect this trial to last?
Max a week.
All right. So, Miss Ferguson, jury trial date 4 days on Darren Doe's.
I'll tell you, last night the storm that blew through in Utah was just fantastic. It was beautiful.
All right, December 3rd.
It was just wind.
Once you sign the reset form, your excuse. Thank you for always dressing appropriately this morning. All right. Thank you.
Trying to bring you the view of the mountains this morning, which is pretty nice. There we go. That's how they look this morning. The wind cleared out all the smog and fog and whatever in the air, and it was just beautiful.
Thank you.
Send me the link about the pickles. Send me the link for sure. Canonical Heat gifted 10 memberships. Thank you very much for your generosity. That is awesome. I'm sorry I missed that. Also, member for 4 months. Sorry, but I've loved every minute. Thanks. Member, not just member of the jury.
Normally, these are done.
Member of the jury. Get the soft seat. Thank you very much. Appreciate your support. The next DNA hearing, Josh says, is on Thursday, September 26th. That works well. That'll be good. Not a fan of the wind. It was probably a good 40-mile-an-hour wind. It was pretty good. I forgot I had turned off my camera so I could see somebody on Zoom.
Okay. We'll do this plea and then we'll do that. Could you call Gary Churek, please?
Melissa, it is very expensive to live in Utah compared to North Carolina. We could afford living in Utah before we moved away, but now we can't afford to move back.
I am. Yes, ma'am.
We're about 2 hours away from, a little under 2 hours away from court for Las Vegas reporter murder trial, the Robert Tellis trial. So we'll have that here shortly. Yvonne, welcome. Welcome. Thanks for clicking the subscribe button. I can tell you weather up here is absolutely beautiful. I know they've had some hot days, but right now it is 74 degrees. It's going to get up to about 89. So a low of 63, high of 89. This is just beautiful, beautiful summer weather, and just sunshine, sunshine, sunshine. Definitely time to go out metal detecting. You guys want Ashley Benefield. Okay, we've got some documents. We've got time to read them. Just one second. Let me see if I can find them where I put them.
Dennis Pellegrini. Oh, I'm calling Dennis Paul Pellegrini. No.
Okay, we've got the motion to disqualify the judge. We're going to bring that in on camera 8. Thanks, Amber. I found it eventually. That's where I found it. Let's start with the motion to disqualify the judge, and then we'll do the motion for the judgment of acquittal.
And then we're going to take up your case, Umberto Caceres, and then Deputy Mejia, and we can put the rest on hold while we take the verdict. All right, court is calling 2024 CR 2938. And I'm sorry, I'll repeat that because I know you have to repeat it for him.
Very well, Judge.
I have the hiccups.
Siempre viendo a la juez, no voltea a verme, si una bloqueada, me conteste. Thank you, Judge.
Thank you. All right, the court is calling 2024 CR 2938, State of Texas versus Umberto Caceres. Could I have parties announced for the record for the state?
Jury Valdez for Mr. Caceres. Jury Valdez.
El señor Jerry Valdez está.
And are you Mr. Caceres?
Sí.
Yes.
All right, we have an interpreter. If you could raise your right hand for me, please. Do you solemnly swear and affirm you will faithfully translate from English into Spanish and Spanish into English, so help you God?
I do, Your Honor.
All right, you can lower your hand if you'll state your name for the record, please.
Mariana Rios.
Excuse me, sorry. Mr. Caceres, all of the documents I'm going to review with you are in English. Were those documents explained to you in Spanish?
Sí.
Yes.
Counsel, do you speak the Spanish language?
Yes, I do, Your Honor. I also read it.
All right, and do you speak and read it fluent?
Yes, I do, Judge.
And were you able to explain these documents to your client in Spanish?
Yes, Your Honor, I have.
Counsel, have you received all of the discovery and did you review it with your client?
Yes, I did, Your Honor. Yes.
The court will find that the state is in compliance with discovery. Mr. Caceres, did you review the document entitled Application for Community Supervision with your attorney?
Okay, I'll be right back.
Did you understand it and sign it?
I just signed it.
Did you understand it?
No lo leí.
I didn't read it.
Now, my question is, did you review it with your attorney and did you sign it? The document is the document that appears to have your signature where you are asking the court to consider your application for probation or community supervision.
Sí.
Yes. Yes.
All right. Did you review the document or have explained to you the document entitled True Bill of Indictment, which is the document that informs you of what the state is charging you with?
Sí.
Yes.
All right. Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
Yeah.
Mr. Caceres, did you review with your attorney the court's admonishment and defendant's waivers and affidavit of admonitions document with your attorney, sign it in all the appropriate places? That is the document that tells you what you're charged with and your rights, among other things. Did you review that with your attorney and understand it?
Sí.
Yes.
All right, you're charged with injury to a child with intentional bodily injury. All right, and you all are charging this as a second-degree felony?
Should be a third-degree felony. I'm sorry if I checked the wrong box.
Oh, no, it's just put on here as second degree, but the appropriate box is checked.
Second, that's a third-degree, Judge. I also would like to add I'm not sure if I added it to the plea bargain when we get there. There are two cases that we will be taking into consideration.
All right. And what two cases will you be taking into
Okay,
consideration?
I missed what the charge was.
Case
Can we
number
bail on this one?
337-323. That is an assault bodily injury, married cohab. And CC 723-596, assault bodily injury, married cohab.
All right, any objections to the court adding that to your plea bargain agreement?
No objections, Your Honor.
All right. So he is listed on the documents I have as Humberto Cáceres Rangel. So what is his name?
Humberto Cáceres Rangel.
Humberto Cáceres Rangel.
In the indictment, he's only listed as Humberto Cáceres.
All right.
Does anyone wish to amend the
Okay,
indictment?
we're gonna bail.
Rangel?
We're gonna bail. Jump ship. All right. We're here. We are jumping. Finally getting caught up with Ashley Benefield. There was so much happening last week that we did not get to these. These were filed 8/9, so we're a week or so late. But I want to go over what's happening. We did follow the trial with her. So let's see. This particular one. This is a motion to interview jurors. Yes, we're hearing about this more and more. But we after a case is over and there's something comes to light that looks like the jurors might have done something wrong, and this is one of the big reasons why jurors really shouldn't talk to anyone after they're done deliberating, because it just opens doors for things like this. Well, now the defense has filed this motion to interview the jurors, and it says, Ashley C. Benefield, by and through undersigned counsel and pursuant to Rule 3.575 of Florida Rules of Criminal Procedure, in conjunction with and as part of her motion for a new trial, hereby moves the court to conduct juror interviews of the jurors in the instant matter. That means in this case. As grounds in support of the requested relief, Ms. Benefield submits as follows. So this is the reason why she should get this. First, background. On July 30th, the jury rendered its verdict. Evidence has come to light indicating that the verdict may be subject to legal challenge due to juror misconduct. This alleged misconduct not only violates the court's explicit instructions, but also infringes upon the defendant's constitutional right to a fair trial and an impartial jury, and subjects the verdict to a legal challenge. During the jury deliberations, a YouTube user, That Hoodie Guy, posted comments on the Law and Crime Network's YouTube live stream of the verdict watch. These comments contained real-time information that could only have originated from within the jury room, suggesting a breach of the court's instructions, the sanctity of jury deliberations, jury sequestration, and Ms. Benefield's right to a fair trial. That Hoodie Guy. The Hoodie Guy, apparently. So Law and Crime has entered the document here. The comments posted on July 30th reveal that at 10:20 p.m., 10 minutes before the parties were notified that the verdict had been reached, that Hoodie Guy posted a comment stating, "Verdict incoming." At 10:25 p.m., That Hoodie Guy posted a comment stating, "Per sources, 5-1 guilty with a man stuck on not guilty or manslaughter." At 10:27 p.m., That Hoodie Guy posted a comment stating, "My sister snuck a flip phone in." At 10:28, That Hoodie Guy posted a comment stating, "I am the brother of one of the jurors. She just texted me this. Per sources, 5-1 guilty with a man stuck on not guilty or manslaughter." At 10:28, That Hoodie Guy posted a comment stating, "My sister snuck a flip phone in. She texted me 5-1 guilty, may compromise on manslaughter." At 10:30 p.m., a mere 2 minutes after That Hoodie Guy posted the jury may compromise on manslaughter, the jury returned a compromised verdict of manslaughter. The timing and specificity of these comments, followed by corresponding jury actions, strongly suggest that that hoodie guy's information originated from within the jury room during active deliberations. This represents a breach of the jury's sworn duty and impacts the fairness of these proceedings, subjecting the verdict to legal challenge. This alleged misconduct raises serious concerns about the integrity of the jury deliberations and the reliability of the verdict. Specifically, it raises questions about a juror smuggling an electronic device into deliberations, which is not permitted in the jury room, real-time communication of confidential jury deliberations with non-jury members, influences external to the evidence presented during the trial may have influenced the verdict, access to unauthorized materials affecting the verdict, and the overall integrity of the fact-finding process being compromised. The prompt removal of these comments from the Verdict Watch on Law and Crime's YouTube channel livestream further underscores the seriousness of this potential jury misconduct. So, Law and Crime, probably moderators, did the right thing and pulled these comments immediately. But it's too late. The fact that they even existed for a split second is enough of a problem. In addition to the above, evidence has come to light indicating the verdict may have been subject to legal challenge due to juror 15, name withheld, being untruthful during voir dire by falsely representing that she had not been a victim of a crime. Her son had been charged with a crime, and she had involvement in child custody, domestic violence, abuse matters. Juror 15 completed the jury questionnaire under the penalties of perjury, which asks, have you or a family member or your immediate family been a victim of a crime? Juror 15 responded untruthfully to the question by omitting that she had been a victim of a crime, battery, touch or strike, domestic related, on February 20th, when her live-in boyfriend intentionally slapped her in the face with open hand 5 times, and that her son had been charged with felony battery against his pregnant girlfriend, on August 31st, for which Juror 15 was the bond depositor. She bailed him out. On March 18th, Juror 15 filed a petition for injunction of protection against domestic violence against Mr. Blank in the 12th Judicial Circuit Court for Manatee County, Florida, case number blank. The allegations of the latest act of violence of threat of violence provided that Blank grabbed Juror 15 by her hair and repeatedly hit her in the face, causing a black eye, damage to the inside of her mouth, and a swollen face. A copy of the petition is attached here to as Exhibit D. This is sad, ugly stuff, but the allegation is that she lied and said this did not happen. Juror 15 was a respondent in a petition for injunction for protection against domestic violence filed September 2nd by her ex-husband, seeking protection for himself and their minor child in the 12th Judicial Circuit Court for Manatee County. A copy of the petition is attached here too as Exhibit E and provides in part that Juror 15 being threatening and violent, including cussing, slamming doors, threatening and throwing things at him, requested that his son come and stay with him until Juror 15 can get some help. Juror 15 attempted self-harm, was hospitalized on or about July 18th. She called and told Mr. Blank that she was going to hurt herself. Constant harassment and threats to his wife and himself, fear that Juror 15 might try to take his son's life along with hers next time, request to keep his son until Juror 15 is well. Specifically, he requested supervised visitation until Juror 15 showed that she was stable mentally and financially. Juror 15 was also the respondent in another petition for injunction against protection against domestic violence, filed on April 23 by her ex-husband, seeking protection on behalf of their minor child. Petition is attached. Allegations of child abuse are in there, that she picked up his son and slammed him against the wall. The minor child, while visiting, expressed that he was afraid to go home. The report of the child filed with the Blank Police Department. Juror 15's boyfriend threatened to hunt so-and-so down and kill them. Ongoing investigation by Child Protective Services, and Blank was seeking custody. The minor child was showing signs of being violent. Juror 15's failure to reveal this information during voir dire amounts to juror misconduct and subjects the verdict to legal challenge, entitling Ms. Benefield to a new trial. So all this stuff, they're basically looking into the background of one juror, particularly the Juror 15, who was asked questions about her life experience and had she or her family member been victims of crime, and apparently failed to relate a resounding yes in this matter, and now they're pulling all this out. Motions filed within the 10-day period prescribed by Rule 3.575 to address the urgent matter. Given the nature of the alleged misconduct, Ms. Benefield asserts that there is reason to believe that the verdict is subject to legal challenge on multiple grounds, including but not limited to juror misconduct, introduction of extraneous prejudicial information, influences external to the evidence presented during trial may have been influenced the verdict, violation of jury sequestration, violation of defendant's 6th and 14th Amendment rights, jurors potentially receiving evidence outside of court proceedings to the detriment of the defendant's substantial rights. The integrity of the judicial process and Ms. Benefield's constitutional rights are at stake. This court has both the authority and the responsibility to investigate this matter fully, including granting permission to interview all jurors who served on this case, to wit, blank, 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 blank. Those are the juror names. We've, thanks to Amber, we have blocked those out. Wherefore, Ms. Benefield respectfully requests the court to grant permission to interview all jurors who served on this case, specifically these ones. Expeditiously set a time and place for the interviews to be conducted in presence of the court and the parties. Summon the jurors to appear at the time and place for the interviews and grant any other relief the court deems just and proper under the circumstances. Respectfully submitted, her attorney. So this is the Ashley Benefield trial. She was found guilty of shooting and killing her estranged husband. And apparently there's some pretty strong evidence that the jury also did something wrong. Let's see here. Let's go into the email correspondence received by the judge. This can be our next one. We're trying to get through all of these before Robert Tellis starts this morning. Continue to scroll and zoom in a bit so you guys can zoom out so you can read it. This is State of Florida via Ashley Benefield. Notice of filing email. Let's check out the email here. Looks like this is 2 Circuit Criminal Division 1. We don't know who it's from. It says, "Dear Judge, my name is blank. I've been trying to contact you for many months. I hope to find you well. This is reference to Ashley Benefield murder trial case. I have some details that may help you in the case. I would have come forward soon, but I didn't know the trial was happening or that Ashley had acted out on her plans. In 2018-2019, me and Ashley spoke on Facebook and Facebook Messenger. I had messaged Ashley, and we had a long chats back and forth for many months, getting to know each other. We shared our life's ups and downs. Ash had shared many things with me, and she expressed many times that she was unhappy, and she had fears that he, meaning Doug, was going to take her baby away from her, and that she would be alone and have nothing. She shared with me that he kept following them and staying in his car watching them. She said she was scared and worried that he may do something to harm her. I said, had she done anything to hurt Ashley? Had she done anything to hurt Ashley in the past? She said yes. I didn't know anything about guns or what she was going to carry out the murder. However, she asked me to harm Doug. She had asked me to harm Doug, and that she would be safe. And she also said that we could be together. I stated, no way, that's crazy, because is he really going for you to want to harm him? She always kept changing the subject around into me, and at the time she stated to me she had over $1 million in life insurance and also Army benefits that she would get each month. I did not know if this is true. We spoke for some months. There's no punctuation in here, so I'm struggling. She spoke for some months. After this question, she kept on and on about doing this. She said she was going to do things around the house to make it look like he was doing things to harm her. But in fact, he did nothing. We spoke about moving guns around, taking little trips so she could come up with planting things or also coming up with an opportunity to end his life. She also sent me photos of the house and other details. She also hated her older sister. She stated she fought about little things and that Doug always stuck up for the older child. She was very flirtatious and desperate to maintain contact. However, I didn't want to be part of this. She kept messaging me and calling me on Facebook. I give us permission to look at the chats between us. I'm in fear of coming forwards and being involved with her again and being out on national TV, and she scares me a lot. Whoa. Where did this come from? We've blacked out the email address, but the name on top, which is filed in the court, is right there. It's right there. That's what it is. So There might be something there as well. Now we'll go to the motion of acquittal and then the motion for the dismissal of the judge in that order. Okay, how are we doing time-wise? We've got 92 minutes or so. All right, motion for judgment of acquittal. This motion, for those that are not familiar with it, is basically when you ask the judge to enter a decision saying, I'm just going to decide right here that you're not guilty. In spite of, I think this is after the jury, this would be a judgment notwithstanding the verdict. So a JNOV, I think they call it. Judgment notwithstanding verdict. Motion for acquittal. Ashley C. Benefield, by and through undersigned counsel and pursuant to Florida Rule of Criminal Procedure, hereby moves for a judgment of acquittal. In support of the instant request, Ms. Benefield submits the state has failed to meet its burden, proven beyond a reasonable doubt that Ashley Benefield did not act in self-defense. As such, Ms. Benefield is entitled to a judgment of acquittal as a matter of law. Sufficiency of the evidence is the legal standard here. The legal sufficiency of the evidence to support a conviction is a matter of law for the court, while the weight of legality and sufficient evidence is for the jury. A finding that the evidence is legally insufficient is equivalent to a determination that the prosecution has failed to prove the defendant's guilt beyond a reasonable doubt. Self-defense and burden of proof. While the question of whether a homicide was committed in justifiable self-defense is ordinarily a question for the jury, courts have not hesitated to reverse jury convictions and discharge the wrongfully convicted when the state fails to carry its burden of proof or when the state's evidence clearly shows that a homicide was committed in self-defense. This is weird because they already had this motion, I believe, prior to the jury deliberating to see if they could get this judgment of acquittal, and it was denied because there was enough evidence to send it to the jury. I don't know how they could then, after the verdict comes in, say, yes, we're going to sustain it. That doesn't work. Let's see. Crucially, the state bears the burden of proving guilt beyond a reasonable doubt, which includes proving beyond a reasonable doubt that the defendant did not act in self-defense. While the defendant may have the burden of going forward with the evidence of self-defense, the burden of proving guilt beyond a reasonable doubt never shifts from the state, and the standard broadly includes the requirement that the state prove that the defendant did not act in self-defense beyond a reasonable doubt. This principle has been consistently upheld by Florida courts. The state has the burden of proving guilt beyond a reasonable doubt, which includes proving beyond a reasonable doubt that the defendant did not act in self-defense. Similarly, in Rodriguez v. State, the court reiterated this standard. Uncontradicted evidence. The legal effect of competent evidence which is not impeached, discredited, or controverted, so there's nothing to say that it's not true. So there's no other competing evidence that presents an alternate set of facts. The person providing the evidence was not impeached, and this in no way has been discredited. So it's a question of law for the court. The court reviewed the testimony of the appellant and his daughter, the only eyewitnesses to the killing, found it to be uncontradicted and unimpeached, and reversed the manslaughter conviction in this Brandon v. State, or is this Harris v. State? That's in Harris v. State. Finding as a matter of law that the homicide was justifiable as having been committed in self-defense. The court, well, let's see, more case law. While this standard requires the court to view the evidence in the light most favorable to the state, it does not relieve the state of its burden to present legally sufficient evidence to support a conviction. So the argument here is that the state failed to rebut the defendant's clear evidence and self-defense. Sorry, I need more water. What you're seeing here is me trying to be good and not drink Mountain Dew again, and I'm struggling today. I'm dragging. Let's see. Florida courts have long recognized that the state bears the burden of disproving a prima facie case for self-defense beyond a reasonable doubt. There's case law, Jenkins v. State. Once a defendant makes a prima facie case showing of self-defense, the state has the burden of proving beyond a reasonable doubt the defendant did not act in self-defense. Here, the state has failed to meet that burden. The uncontroverted testimony of Ashley Benefield, the only eyewitness to the incident, the only living eyewitness to the incident, establishes a prima facie case of self-defense under Florida law. Ms. Benefield's testimony detailed a series of escalating aggressive acts by Doug Benefield, culminating in a violent physical assault and a situation where she reasonably feared for her life. Ms. Benefield testified that on September 27th, she and her husband Doug were loading items into a U-Haul truck. Ashley had prearranged with Doug that her belongings would be loaded last for easy unloading. Upon inspecting the truck, Ashley noticed the items were mixed together, contrary to their agreement. When she pointed this out, Doug became visibly upset, loudly stating it shouldn't be your stuff, your house, my house. Then he demanded that Ashley start acting like a wife. As the day progressed, Doug's behavior became increasingly aggressive and threatening. Ashley, attempting to avoid confrontation, tried to de-escalate the situation by changing the subject and repeatedly suggesting they finish for the day, saying she was tired. However, Doug completely disregarded her efforts and became more agitated. The situation escalated to physical confrontation on 3 separate occasions. Well, first, in the living room, Doug deliberately body-checked Ashley with his shoulder, catching her off guard and causing her to stumble and almost fall. During this incident, Doug was clearly hostile, mumbling under his breath and glaring at Ashley. Second, in the garage, after Ashley strongly suggested ending the day's work, Doug again body-checked her, demonstrating a pattern of increasing physical aggression. Third, in the hallway, Doug intentionally and forcefully drove the corner of a box into Ashley's right hip area. He looked her directly in the eye while doing this, showing clear intent. The impact caused scratches and a burning sensation. After the third incident, Ashley, feeling frightened and desperate to prevent further aggression, apologized to Doug, despite being the victim. Doug then continued to the garage with the box. Uh-oh. I just saw what's coming up. There we go. The situation continued to deteriorate rapidly. He began screaming at Ashley, yelling, "Shut the up," and calling her names. He accused her of trying to make him leave and threateningly asserted, "I don't have to leave. I can stay and spend the night if I want because I'm your husband." At that point, Ashley was terrified for her personal safety. In a desperate attempt to escape the volatile situation, she ran towards the front door in an attempt to leave the house, but Doug physically restrained Doug, who grabbed her by the hand and yanked her back. He maneuvered himself between her and the door, trapping her. With menace in his voice, he demanded, "Where the do you think you're going?" In a moment of sheer desperation, Ashley blurted out, "I'm done and you need to leave now." Doug's chilling response, "You can't leave me," was followed by an unprecedented act of violence. He struck Ashley on the side of her head. This was the first time in their relationship that Doug had actually hit her, marking a terrifying escalation of his abuse. Panic-stricken, Ashley ran to her room, the only place she thought she might offer some protection. She grabbed her gun, her heart pounding with fear. This is like written like a story. And as she did so, she heard the ominous sound of the door hitting the doorstop, signaling Doug forcefully entering the room. The sight that greeted Ashley was nothing short of terrifying. Doug stood in the doorway, his face contorted with rage, red with veins bulging in his neck. His eyes, which Ashley described as black, he uttered the chilling words, "You're done." In a desperate attempt to stop him, Ashley held the gun in front of her and yelled, "Stop." Instead of retreating, Doug assumed a fighting stance, bladed, crouching, and making erratic jerking motions with his arms and hands. Ashley thought Doug would leave when he saw the gun. To her horror, he did not. Miss Benefield was trapped in the room with Doug between her and the only exit. In that moment, Ashley believed she was in imminent danger of death or great bodily harm at the hands of Doug, as he was visibly enraged and had struck her on the side of her head just moments before. As he lunged towards her, she began pulling the trigger in sheer terror. Even as she fired, Doug kept advancing, his determination to reach her seemingly unaffected by the gunshots. Ashley, in her panic, moved laterally toward the side of her bedroom to get away from him. She described the entire ordeal as chaotic and terrifying. The confrontation ended when Doug's feet appeared to slip out from under him, his legs going up in the air as he fell backwards. Still gripped by fear, Ashley immediately ran next door to John Stant's house for help. When asked why she shot Doug, Ashley's response encapsulated the sheer terror of her experience. "I was scared to death. I thought he was going to kill me. There was nowhere to go. I was trapped in my own home. He wouldn't let me leave." The trauma of the event was evident as Ashley described what happened. Ms. Benefield's testimony established all the elements necessary for a claim of self-defense. Critically, the state presented no evidence to rebut Ms. Benefield's direct testimony that she acted in self-defense, nor was it able to diminish her testimony on cross-examination. The unrebutted direct testimony of Ms. Benefield demonstrated that due to the threatening conduct and actions of Doug Benefield, she reasonably feared for her life and believed that deadly force was necessary to prevent imminent great bodily injury or death. The unrebutted testimony also established that Doug had committed a forcible felony, i.e. false imprisonment. Circumstantial evidence insufficient to overcome direct testimony. More case law. When the defendant presents a direct testimony of self-defense that's not rebutted by the state, only those inferences properly arising out of the state's testimony in chief can be considered to rebut the defendant's assertion of self-defense. This seems like something that should have been brought up in the jury instructions. Not sure if I'm going to read all this. Mostly because my brain's getting tired. I want to save some brain cells for Robert Tellis today. Let's see. She's listening. The state's witnesses are categorized as background and purported motive witnesses, crime scene technicians, responding officers, other witnesses, state's medical examiner. And we go through a lot of Q&A. Okay, this one is not so spicy. Evidence supports self-defense. Evidence is legally insufficient to overcome the presumption of innocence. The evidence is insufficient when viewed in the light most favorable to the state. This I don't agree with. Usually the light most favorable to the state means if there's anything, then the state wins. Court's threshold determination and the state's failure to contradict testimony. Can you hear the singing? My kid's singing in the other room. Conclusion. Based on the foregoing analysis of the Florida case law and the evidence presented at trial, it is clear that the state has failed to meet its burden, proven beyond a reasonable doubt that Ashley Benefield did not act in self-defense. This failure is manifest in several crucial aspects of this case: the insufficiency of circumstantial evidence, the lack of contradictory evidence, the failure to rebut prima facie case of self-defense, absence of physical or forensic evidence, threshold determination, insufficiency even in the light most favorable to the state. The law is clear. The version of events related by the defense must be believed in the circumstances do not show the version to be false. Here, the circumstances not only fail to show Miss Benefield's version to be false, but in many ways corroborate her account. The state has failed to present any evidence that directly contradicts Miss Benefield's account of the events inside her bedroom on the day of the question. Therefore, in accordance with the principles outlined in Fowler and a long line of cases it synthesizes, it is this court's duty to grant a judgment of acquittal. This applies not only to the charged offense, but also to any lesser included offenses not supported by the evidence. The state's failure to contradict Miss Benefield's account left no room for a jury to legitimately find guilt on any charges related to this incident. Wherefore, Miss Benefield prays the court grant her motion for judgment of acquittal. Post-verdict judgment of acquittal. Now we get to the spicy one. The last one we're bringing in is motion to disqualify the judge. Let me look at chat really quickly. Hang on. No, Deb, you did not miss the spicy one. That's coming. Hold on just one second, though. I'm trying to see what I missed in chat. Let's see. Dawn, did we welcome you to the gallery already? Thank you very much. Patricia Hernandez. Hey, guys, 2 months. Welcome. Zachary Wells gifted memberships this morning. Canonical Heat, thank you for the generous gifting of memberships as well. John Link, booyah, 16 months. Thank you, John. Green-Eyed Cat. Richard Chambers, I think we got those ones. Ricky Watson, Tori the Seed Lady. Greeners was in there as well. And Patricia Hernandez. Thank you, all of you. You're super generous, and congratulations on your respective memberversaries. I can hear them singing. You've got to be able to hear them singing. What is that sound? I don't know what they're singing to some like Minecraft movie on YouTube or something. I have a P.O. box. It's back in North Carolina. I'm in Utah. I don't have a shipping option while I'm on vacation. You guys are ready for the spiciness? Let me check the calendar really quickly. I've got 70, 80 minutes or so. 1 second. All right, they're going to sing quieter or downstairs. Let's see. LMR, I just figured this out. 3 months later. Congratulations, LMR. We expect monthly memberversary messages from you now. If you reside somewhere for more than 30 days, don't you assume residency? It's 60 days, I think, and you have to surrender your old place. Have no intent of going back. We haven't done that. Cars there and everything. Tony Green, don't feel bad. Just turn on your gifts setting and make sure exclamation point gifts, that's gift with an S, you've got the setting turned to yes, and you'll probably be gifted a membership at some point. This is the P.O. box in Ayden. They are holding my mail for me, which is great. I'll be getting it sometime mid-September-ish. So don't send anything that would spoil. Usually don't send anything that would spoil in the mail anyway. But let's go ahead and jump over to, well, you already have been seeing this, so now I can see it. All right, Ashley Benefield's motion to disqualify the Honorable Stephen M. White, supporting affidavits and incorporated memorandum of law. The right mouse, there we go. Ashley Benefield, by and through undersigned counsel and pursuant to Section 38.10, Florida Statutes 2023, and Rule 2.330 of the Florida Rules of General Practice and Judicial Administration. Thank you very much. Mandy Winslow took the day off because the car needed audio services done, so I'm here with y'all today. Sounds good. Hereby, Ashley Benefield submits her sworn motion for disqualification of the presiding judge. Disqualification. Ms. Benefield fears and believes in good faith based on objective facts. She will not and cannot receive a fair hearing and or sentencing on account of the personal bias and prejudice of the presiding judge against her and in favor of the state of Florida. The court's conduct in open court immediately prior to commencement of trial on July 22nd and at the July 30th verdict improperly prejudiced the defendant. Specifically, the court's declination to voluntarily step aside, as well as the court's arbitrary and capricious refusal to even so much as even acknowledge Ms. Benefield's request for a post-trial bail, created such apprehension for Ms. Benefield that she reasonably fears she will not receive fair hearing or sentencing because of the court's personal bias and prejudice against her. Hang on. So, when trial starts, they're like, Judge, we don't like you. Will you step down? She says no. And then afterwards she says, oh, I've been found guilty, but can you grant me bail? And the court said no. And they're saying that is the clear prejudice, personal bias and prejudice. I'm not buying. I don't smell what they're stepping in. I'm not buying that. No previous disqualification motion has been filed in this case, and a transcript of the post-verdict bond request is attached. The actions taken by the court, its refusal to even acknowledge the defendant's motion, yet alone entertain, evaluate, and rule on it, plainly appeared to the defendant that the court never intended to consider it, and remand was the only option. Given the court's consistent display of prejudice against Ms. Benefield and in favor of the state throughout the trial. Okay, now, refusing to even acknowledge the motion, that might be a problem. They might have some grounds there. It's the established law of the state that every litigant is entitled to nothing less than the cold neutrality of an impartial judge. I'd like more than that. I'd like a little warm and welcoming demeanor. In this instance, Ms. Benefield received anything but that. Canon 3 of the Florida Code of Judicial Conduct declares that a judge shall perform the duties of judicial office impartially and diligently. Under subsection E, entitled disqualification, it states that a judge shall disqualify himself or herself in a proceeding in which the judge's impartiality might reasonably be questioned, including but not limited to instances where the judge has a personal bias concerning a party. The judge, while a judge has made a public statement that comments or appears to commits or appears to commit the judge with respect to an issue in the proceeding or the controversy in the proceeding, quoting this, okay, so they should resign if they have done anything that might look like they're biased. Donna J, best channel on YouTube. Thank you, R.A. Donna, congratulations on 6 months. Hope you love that yellow courthouse. It looks great on you. Thank you so much. Mistrial also just says, just 4 months. I'm still in the incubator. Awesome. We love it. Welcome. Good to have you with us, Mistrial. I'm not seeing in this a lot of reason to dismiss. This seems like weak argument. Now the jury misconduct, that is strong argument. This is weak. Very, 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 very weak. It's weird. I'm using 2 identical wireless mouses to run 2 different computers at the same time, and I'm failing miserably at both. Okay, so this is that one. Sweet and salty. Thank you very much for your 3 months of support. Congratulations. Yeah. They did all the filings. They threw everything at the wall is what happened, Lizzie. They actually did. Everything they possibly did. The only thing they haven't done is asked to dismiss the prosecutors, which I guess it's a little late for at this point. Okay. Let me scroll through some of this. Messages are coming in fast. ACDCS Oversight Group just gifted a membership. Thank you very much. That one went to Pamela. Also, Kathy Davidson, been around for about a year. Took me 6 months to figure out YouTube. I'm glad to be here. Well, we've got you that yellow courthouse now, so hopefully that'll keep you happy for a little while. Thank you very much for your continued support. Okay. This motion to disqualify is weak. They say that immediately prior to the trial getting way, before voir dire and the jury selection began, the undersigned counsel began. Before jury selection began, undersigned counsel appealed to the court's sense of integrity and oath of office, wherein the court agreed to uphold the fair trial provisions of the Constitution of the United States, as well as the Constitution of the State of Florida, and beseech the court to disqualify itself and step aside. So even before jury selection began, they've already said, Judge, I don't think you can be fair. Specifically, undersigned counsel raised the issue of court's conclusion embodied in its order denying Ms. Senefield's stand your ground motion, and inquired how the court could possibly sit and decide the issues objectively when it had already publicly concluded Ms. Benefield was guilty as charged. The request was ignored. So the stand your ground, she had a hearing for stand your ground, and she lost that hearing. And that's why the trial went on the way it did. Karen Dietrich says, this is the best YouTube channel because of you, Recovery Addict, and the most giving chat and wonderful mods. I agree with most of that, Karen. This community is what makes this the best. I'm just lucky to be a part of it. Thank you. Congratulations on 15 months. Let's see. So they were mad ever since the stand your ground hearing. And they have reasonable fear that they won't receive a fair trial. They sought to disqualify the judge for alleged bias. Tom Taz, yes, they're trying everything, but one of their arguments is actually solid. Let's see, alleged bias, case law, showing bias, that the court should stand aside if there's any doubt as to their credibility, or given the court's stand your ground order, Ms. Benefield surely has reasonable grounds to believe the court has prejudiced her credibility, and anything she said at trial or will say at sentencing will be ignored. But even more immediately, for purposes of post-trial release, the court's indifference and refusal to even entertain her request leaves her with reasonable apprehension that creates in the mind of Ms. Benefield and her attorney that such efforts will never be evaluated objectively. Okay, if they made a motion and the judge just refused to even read it, that might be a problem. That might show bias. But if the judge just said denied, that's considering it. She considered it. She ruled on it. You might not like the way she did either of them, but that's considering it. Oatmeal. All these documents are available over on the Discord page. If you join Discord, in this case and on pretty much every other case, you'll find documents available over there. Otherwise, you have to search them out manually in various court systems, some of which cost money, some of them are free, but they're all different and they're a pain in the butt to deal with. Disqualification is required when the trial court states its belief that a party is guilty prior to trial on the merits. Additionally, Ms. Benefield, now having testified, little doubt remains the court has concluded her testimony was untruthful. Ooh. Here's the problem, though, I have with this. It's my recollection that Ashley Benefield did not take the stand in her stand your ground hearing, that she did not testify. So the court had no evidence to rule on other than a filed statement saying this was self-defense. If she had testified at that, then maybe she might have different grounds. But Mindful Crafts by Donna. I've been here a lot longer, but these 2 months count. They sure do. Thank you very much, Donna. Appreciate you. Congratulations on 2 months. Do you need to be a member for Discord? Nope. Discord is, let's see, is it popping up here? There should be a command. Is it not working? Pretty Eyes says he heard it the first day of trial. Her attorney even asked for a continuance the day of trial, and the judge heard him on that motion. So yeah, this is a poor argument then. Here's the Discord link right there. If you click on that, if you're not familiar with Discord, it does have a little bit of a learning curve to it, but we have some very, very friendly people over there. This is the As the Gavel Drops Discord page. They're friends of the channel. I don't run it. I'm just a guest there and love it just like the rest of you. But you can click there. It is free, although if you feel inclined, if you like what you use there, like what they provide there, and like what they've built, there are ways that you can drop a financial incentive, basically pay for a small portion of what they get from Discord, and it helps them. What's it called when you do that? When you sponsor the server? I can't remember the term for some reason. They'll tell me in chat in just a second. Not a donation. It's boost. Yes, you boost the server. That's it. You can boost the server, which for just a couple dollars, it will provide a increased level of support or increased level of access, so they can have more documents on their list at once. They can have voice chat and a couple other features that are really fun to use. So I highly recommend, if you like what you see over there in Discord, that you take an opportunity, at least occasionally, to boost the channel. Ashley did take the stand. She took the stand in her trial, but did she take the stand during her Stand Your Ground hearing? I didn't think she did during the Stand Your Ground hearing. All right, so let's see if there's any other argument given here other than that not in the Stand Your Ground. Yeah, I think that was a failure. I called it out when I first heard that. I said I think that was a bad move. So this is the only reason they're citing in this motion to disqualify the judge. Conclusion. Let's see. Given the court's public statement relative to Ms. Benefield's guilt, its history of impeding the defense on every turn, its handling of the questions leading up to the verdict, and refusal to even respond to counsel's post-trial bond request, all created a well-founded fear Ms. Benefield would not receive a fair trial and or sentencing before this court. Ms. Benefield objectively believes that the court now has prejudiced her entitlement to post-trial release, and her sentencing shall be characterized by an equally biased judicial perspective. Under these circumstances, the court is obliged to grant the disqualification request. It would have been appropriate for the court to have voluntarily stepped aside when the counselor requested it, immediately prior to the commencement of trial. Now, given what transpired since that request was made, Ms. Benefield involves a formal written request supported by objective facts as well as independent affidavits and undersigned counsel certificate of good faith. There you go. So they now officially are asking for the judge to step aside. prior to sentencing. I don't think that's going to happen. But this jury thing, I think that might happen. And Law and Crime, YouTube's probably going to get subpoenaed to try to find out who the IP address is for that chatter. Because you think you're anonymous on the internet, but you're not. Susan summarizes the documents. Anyone who doesn't agree with me is biased. Defense presented nothing at stand your ground. Yeah, they had nothing to go on. Literally, a stand your ground hearing requires evidence. Okay, evidence has to be presented. And when the state presents evidence saying, hey, we think that she shot him in cold blood, and just staged the whole thing, and they sit mute, this is when you're saying it's self-defense, you have a burden to carry that, to present the evidence to say, yes, it is self-defense. Had they presented it and the state then had nothing to contradict and say, we don't have any evidence to prove what she said was not true, they could have been dismissed right there and this never would have gone to trial. What happened with the YouTube chat? Living Ghost, the first document we read in this Ashley Benefield saga of filings, post-conviction filings, is a request to interview the jurors for juror misconduct, and also a request for a new trial is basically what they're getting at. And there appears to be one commenter on the Law and Crime chat, in the chat room for Law and Crime, that seemed to have inside information about the courtroom, was saying that his sister was on the jury, that she had snuck in a phone and was getting him messages somehow, and knew before announcements were made what the announcements were going to be. So it looks quite authentic. It looks like it's self-authenticating, enough so that I think it would be inappropriate to not do at least the jury questionnaire or the jury interview. People always say stuff like that, Guy, during the verdict watches. Yeah, and it's wrong, but everything he said was right. Like, he nailed it, even to the time when a decision was made. He knew 10 minutes before it happened. So it looks really bad. All right, we have done a little bit of court hopping. We've done a little bit of Ashley Benefield catch up. Let's see. We've got this breaking news out of Kentucky with a shooting at the courthouse steps that left 3 people dead and the shooter still at large. Crazy morning. We're going to skip Young Thug for today. Could jump back to Kansas briefly. I hear a lawnmower. Ooh, Thurston County's doing something. What's up here?
I work at a children's hospital. I have 2 kids of my own. I'm not here for all that. That's not. I just want to communicate with the person that I thought I actually enjoyed their time with and spent time with. And that's what I'm here for. And I just wanted to communicate with her that she did not want to communicate with me. And it leads you to a bunch of chaos in your own mind. So that's what I'm here for. And I'm here to move forward. So, like I said, yes, I'm going to deny the order.
It sounds like a drug court situation, but I can barely hear him. So we're gonna bail on that one. Let's see. I think okay. We have just under an hour before Robert Tellis starts. A 1 unalive, 3 total shot, 1 in surgery, and unknown on the 3rd. Shooters in the standoff with the pew pew. Oh my goodness. Kelly May, is it worth, it's probably going to be on SWAT tactical channels now, so probably police scanner's not going to be too helpful at this speed. Megan, what's probably more likely is you've got someone that keeps using the restroom and giving updates when they go to the restroom. So a phone in the pocket. We are not following that case, Lily Wayne, the torture case. Is that the one you're talking about? I think they're still in verdict watch. Yeah, anytime there's a standoff, generally by that point, the police incident command system will have switched from local police traffic, like the regular broadcast frequencies, to encrypted tactical channels, just in case that the suspect may have access to listen in as well. What do you hear from your neighborhood in West North Carolina? Nothing. Crickets. That's it. Just seeing flooding pictures. Haven't decided on Donna Alderson. Adelson. What's the date on that one? There are some states where, well, I'm in Utah right now, so I'll tell you what Utah's rules are. There are some states where media can pay for and receive a police scanner with encryption keys. They do this under the agreement that the audio from the encrypted channels is not transmitted, recorded, or played back. So that and information that they hear as they're monitoring that is not provided live to viewers, even relayed live. So there are some states that allow that. A lot of places they just say, nope, it's encrypted. We won't let anyone hear it. I'm not a big fan of that. I really think the media should be able to oversee what government does in just about every facet. Even though that was a definite detriment to law enforcement and in secrecy and things like that. Dr. Bullbutter. The cat's being fed and is fine. The cat's doing great. I think the bigger deal in Benefield was filed was about Juror 15, who apparently was a victim of domestic violence and lied to get on the jury. I did shave my beard and I got a haircut pretty much within 24 hours. The police here were wondering why the media suddenly stopped reporting on all the good work they do once they encrypted their dispatch. We've got a jury trial in Thurston. Let's see. Thurston County District 4.
I don't want to, what you're looking at in me. I don't want you thinking that I'm thinking I'm above the law because I'm trying to get things straightened out here. I want these issues behind me.
This is not a jury trial.
I was only trying to put bread and butter on my table. Like I said, I've been going back and forth to work. There's nothing else I can say, you know. I do apologize for the burden of taking up your time with this case here, you know. And I'm ready to face the consequences now, you know. I said I have applied for the interlock, you know, that's what I have to have. Where my confusion lied, I was out in Montesano one day. I was at court, and the judge there I heard her waive the interlock for this other guy, right? Because he didn't have no alcohol in his system. So I went to the Department of Licensing. I was asking them what I had to do, and they to get it waived. And they were telling me I had to go back in front of the judge that sentenced me on DUI. I go in front of him, and he tells me no, it's up to the Department of Licensing. So I'm kind of confused now. I'm at the point right now. I just want to get it behind me, and I'll do what I have to do, and then continue on.
You know, that explains the issue on the
Tellus trial starts in just under an hour.
It's a significant issue. What you're also doing is you're driving.
Yeah.
And you know you can't drive. It's been that way for a long time.
Yeah.
And you've just made a choice that that's what you're going to do. You haven't figured out how to either get your license back, pardon me, or how to not have to drive. Whether that means moving next door to work, or that means getting a pair of walking shoes or a bike or whatever, and doing something. But that's what you have to do. Until you have your license, you can't drive. And I suspect you probably drove here today.
Yeah. This is one issue that the Department of Licensing.
Don't admit that you drove here today. I'm just telling you I suspect you drove here today.
Don't admit.
And, you know, I'm pretty sure I'm right. I will tell you that at one point in time, this court, not me, but this court would take somebody like you, and I would say, give me your keys. And we'd take your keys, put them in a box in district court, and hold them there until you showed up with a license, which meant your car would sit in the parking lot for months.
Yeah.
Or whatever car you drove would sit there. And that's what the court did. One particular judge did. And one, you don't want to put us in that position. You have to stop driving. You have to figure out your life without a car. And I know you live down in Rochester, and I know the deal with that. And you know, it's tough to go someplace, but you're going to have to rearrange your life to make it happen.
Not for me to get an occupational license. This is one. There was a list of things that I had to take care of for the Department of Licensing in order to get an occupational license, and this happens to be one of them. I am taking steps that.
Okay. But in the meantime, you have to stop driving. You can't say, I'm working on it, so I'll just keep violating the law.
Driving.
You have to park the car. You have to have friends, you have to hitchhike, you have to get a bike, you have to do something.
Right.
Judge recommending hitchhiking. Wow, that's the first.
You know, I appreciate your word that you said. Probably what you heard Montesino was a judge talking to somebody who was there pre-trial, saying, okay, because your charge doesn't involve alcohol, I won't require you to have the ignition interlock pre-trial. Once it gets a conviction, then it's up to the Department of Licensing. They're the ones who make that determination. So you have to deal with them on the ignition interlock. So in your case out of Centralia, that's the judge is right. You have to go to the Department of Licensing because a conviction's a conviction, and they'll tell you what you need.
Okay.
What you heard Montesino was something different. She wasn't convicted yet. That's why you heard what you heard.
Okay.
All right. But you're hearing from me, you can't drive. So the 90 days is suspended on the driving charge, 364 in the ignition interlock, and with your record of just constantly driving, I suspect the reason this agreement was made is the state, if you get another charge, you're in Thurston County, the state will recommend substantial jail time on both the ignition interlock if you're violating that, and the driving suspended if you're violating that. So don't put them in the position of having to do that because they don't want to do that. Don't put a judge in the position of having to say, okay, you've not paid attention to this, so we are going to put you. It sounds to me like you are paying attention to it. You're just going to have to make different arrangements. And it can't just be, I live in Rochester, I have to get to work, so I got to drive. That's
I ride back and forth to work now. I did get a ride up here today.
Did you? Okay. Anyway. Plus, riding a bike or walking is really good exercise.
It is.
All right. Spend all the jail time for 2 years. Don't drive to have a valid license, insurance, or be any order concerning ignition interlock. I hope you're able to work all of that out. Get to where you actually have a license. You don't have to be looking over your shoulder every time you're driving.
Actually, you have to keep checking your blind spots even while you drive.
I hope we get to that point. I will give you a copy.
All right, we have just a little bit before Robert Tellis' trial starts. I'm going to take a very quick break. I think my family's trying to schedule a trip. I might be losing my phone for the day so they can get there and back. You only need a license to be pulled over. Ayden, I cannot agree with this. This is like Sovsit argument from you. We have almost 100 missing women up here in British Columbia on a 500-mile stretch of the highway. That is terrible.
Hale, see in the, is something happening on the walking?
What's happening? The Highway of Tears. Are there? What's the circumstances of their disappearance?
Oh dear. Have a good walk home.
Yeah, I will. Thank you.
Yes, sir.
And Your Honor, the short answer on the Walker case is I've extended an offer on the case. I don't know what the status is at this point.
Ms. Smith, do you have any idea? I mean,
I can reach out, but I'm sorry, who are we talking about, Your Honor?
Okay, Mr. Walker. Jonathan Walker. Wait. Yeah, you probably don't know because Mr. Kale was on. I guess he's in my case in the courtroom right now. Mr. Walker, good morning.
Paging Mr. Walker.
Hi, I'm not sure if you guys are talking about Keontae, but I'm a female.
I'm sorry?
I'm not sure if you're talking about Keontae Walker, but I just wanted to clarify I'm a female.
I am. Okay. Thank you, Ms. Walker. Sorry. There we go. And have you spoken to Mr. Kale this morning, Ms. Walker?
No, I have not.
Are you anticipating entering a plea of guilty today? Is that my understanding?
I'm not. I'm waiting to speak with him.
Okay. He was on earlier. He's not on now. We're hoping that he'll come back on and let the two of you talk and then tell us what you're going to do. Okay, so you're in the right spot.
Okay.
Tellis trial starts in 45 minutes.
When we can call your case again.
Okay, so I'll just wait.
Yeah, thank you.
I just sent a message to her to say, and see. I sent a message to him. I said a message.
I will abstain from sending a message.
Okay, looks like Mr. Burge is present in jail.
Mr. Burge in jail.
We are ready to proceed today, Your Honor.
All right, Mr. Burge, good morning.
Good morning.
Okay, Mr. Holcomb, stay ready to proceed.
Yes, Your Honor, the state is ready to proceed today.
Just for the court's information, there are the expected witnesses will be Washington State Patrol Trooper.
Hold on.
Oh, sorry, Your Honor. Jumping the gun here. Too much caffeine this morning, I guess.
Not enough for me. I have not had a Mountain Dew since I drank them. The last one was on Saturday. So it's been more than 24 hours, and I'm crashing a little bit. I know that if I continue to just not drink Mountain Dew for a little while, the crash will go away, and my body will just regain its normal energy. But if I get a Mountain Dew, then I will just become more dependent on it. So I'm not a green tea fan.
Mr. Kale is apparently arguing a motion in courtroom number 1.
Okay.
All right, we have set up a thumbnail for the Tellus trial. We've also set up a portal that will take us from here to that. It's going to be less than an hour before it begins. I think I'm going to take just a very quick break to get some family things sorted out. As now my entire family is here.
And Mr. Burge, am I pronouncing your name correctly?
Who's going to be getting married next month.
So it's Kenny Burge.
Yes, sir.
Do you happen to know Mr. Farag? Kenny? Any evidence that Mountain Dew is bad for you? Crunchy Frog, I would say Exhibit A is evidence to me that Mountain Dew is bad for me because when I drink it, I feel great. And when I stop drinking it, I feel absolutely terrible. Worse than if I had not drunk it in the first place. So I would say it's a net loss.
Mr. Hawkins, charges stage proceeding are both reckless and DUI?
Yes, Your Honor.
Reckless and DUI.
Okay, the reckless is not based on the DUI, the reckless is something else.
The reckless driving, Your Honor, is based on the speed as well as the driving around other vehicles. So it is based on the driving behavior exhibited during the DUI. The separate element there is impairment.
I don't like that. I don't like getting charged with a million different offenses.
Okay. And for the state, the names of the witnesses?
The names of the witnesses, Your Honor, are Washington State Patrol Trooper Matthew Neiman and Washington State DAC Technician Zach Riviere.
Second, Matthew Neiman.
Yep. Do you want me to spell their names? Okay.
Nieman.
Niemann. Let me double check that because I think I misspelled it on the trial schedule.
This is a very inviting courtroom. It's not a courtroom, and that's the reason. It's a conference room from like a converted hotel or something. I don't know.
Yes, 2 N's at the end.
Okay. And then the breath tech was?
They've made it into a courtroom.
Zach Riviere.
Last name.
RIVIERE. Let me just double check my work on that.
I'd never had a jolt, but there was a time when I had the Mountain Dew version of the energy drink. What is that?
And
I've had a couple of those, and wow, that lights me up.
And those are your 2 witnesses.
Yes.
And Ms. Simmons, on behalf of Mr. Burge.
Your Honor, we don't anticipate calling any witnesses. However, we do want the court to know that we have not had the opportunity to interview either the technician or the trooper. My investigator did begin reaching out to the trooper in June and was not able to contact the trooper. And as far as the technician, I believe, made contact our investigator this morning. So we want time if we are not able to arrange that today. Mr. Holcomb has said noon, which I'm not sure if that's noon or 4 p.m. I'm not sure if either one of those times are going to be doable. I'm trying my best, but so I may need some time reserved tomorrow morning to talk to those individuals.
Well, they're beginning court, and you haven't talked to the 2 witnesses?
Yeah, I don't want to do it to keep the jury waiting, so let's make it happen today.
Try our best, Your Honor. That's not our...
Well,
not our...
I mean, honestly, if it doesn't happen today, I don't think I'll have the jury tomorrow. The step is to start.
No, then we'll make it happen. It's not our preferred mode, just because it makes everything more difficult when people have reached out multiple times.
Hang on one second. Hello? Hello?
Hi, Dwayne. My name is Jesse. I was giving you a courtesy call on behalf of Primetime Travel Resort. How's your day going?
It's going well.
Good. I'm glad to hear that. I was reaching out today because I'm showing you had a vacation package you never got to book on. Do you still see yourself traveling in the future?
I'd like to, yeah.
Okay. First thing I do need to go over with you is this package will be good for a lifetime. So if it takes you 6 months or 6 years, you'll still be able to use it. You can also transfer it to your friends or family at no additional cost, as long as they are over the age of 25. To start you off, you have 2 5-day, 4-night. Yeah.
There's somebody yelling in the background. I can't. What did you say? It's good. It never expires.
Yeah, it won't expire. You can also transfer it to your friends or family at no additional cost, as long as they are over the age of 25. To start you off, you have 2 5-day, 4-night resort stays. The first in Las Vegas. The next one's going to be in Orlando. You'll be 15 minutes from all your major theme parks. You also have an 8-day, 7-night flex cruise. You can book through either Royal Caribbean, Norwegian, or Carnival Cruise Line. And then last but not least, you have a 3-day, 2-night mini vacation. And for this one, you get to choose the city you take it in. And we're going to cover your airfare for 2 people. I do see you'll be responsible for a booking fee, but I'm also seeing you qualify for something special. Give me just one moment, dear. I'll pull up your account and see what that is.
I'm trying to keep notes. The first one's in Vegas. It's hard to hear you. Can you speak a little louder?
Yeah, sorry. The first one will be in Vegas and the second in Orlando. And then you also have the 8-day, 7-night cruise.
All right. Wow.
And a 3-day, 2-night mini vacation. And for that one, you did get to choose a city, and we're including airfare.
Okay.
Give me just one moment, dear. I will pull up your account and see what I can do for you.
Okay. And what's your name again?
My name is Jesse.
Okay, Jesse. Thank you.
No problem. Hi, thank you for holding. My name is Samantha. I'm one of the travel coordinators here. I just popped on the line to further assist you. Hi, how are you?
I'm already being helped by Jesse. Jesse's helping me already.
Jesse just transferred you over. Yeah, Jesse transferred you over site credit.
Okay, I could hear her a lot better. It's really quiet on your end. Can you speak up? Well, apparently they don't like yelling at people, so she hung up on me. Well, she probably just disconnected.
Hey, Dwayne?
Yes.
Hi, this is Jesse again.
Yeah. I couldn't hear. Another lady got on, but I could barely hear her.
Yeah, she's a travel coordinator, so I was reaching out to her because she has better deals than I could give you.
Okay. The one you had sounded pretty good. I mean, I'm not asking for
you just want to stick with that?
It sounds good.
Okay, because you also... Is it this one? Okay, I'm seeing the bonus that you did have was an 8-day, 7-night worldwide condo stay on top of the other ones that you did have. And our initial... Hold on 1 second. You have 1,700 destinations for your worldwide condo stay. Did Vegas and Orlando sound good to you, or would you like other options?
I have a warrant in Vegas. I can't do that one. I can go there, but I just can't get caught there. Is the only thing. So I gotcha. Yeah. Is there any other option?
Yeah, I can go ahead and lock those. You can choose at a later date which ones you do want to accept.
Okay.
We're going to give you 43 destinations on that to choose from, okay?
Oh, man. I have a hard time picking ice cream. Like when I go to like Baskin Robbins and they have like 31 flavors, I'm there for an hour.
Yeah.
I'm like tasting each one. I don't know when I'd be able to make a decision. Well, you say they never expires,
You got a lifetime. Yeah, you got a lifetime to use this. And like I said, you could also donate it to, or transfer it to your friends or family as a gift as well.
Could I transfer it to like a living trust?
Yeah, you could do. Yeah, you could do that. Because
Okay.
all they would need was your confirmation code to go ahead and give that away. Okay.
Tell you what,
Usually,
Jesse, you've been so helpful. I'm gonna gift it to you because I mean I'm feeling generous. I like vacations, but I don't need it. Jesse doesn't want the vacation. Out of the kindness of my heart, I was gonna give it to her. I've never had them come back on the line after they disconnect from me before. That is hilarious. That is hilarious.
Call from
Supervising Travel Director.
Hello, Supervising Travel Director. This is Dwayne. Hello.
Hey, what's going on? I was just wondering if you could do more of those because I do those all the time and I cannot wait for someone to call me like that. I keep them on the phone for an hour.
I love it. I feel bad. Usually the ones we keep on for a long time are really nice people and they think they're actually working with a
lot of them. A lot of them just want to get down to the nits and grits of it and your pocketbook and your wallet and your card and what you have. But I can wait. I haven't got one of these people calling me in months because I think I'm on the do not call list in their centers.
I think I could give them a referral. I'm sure they'll take referral numbers.
Yes, please. Well, you have my number.
Yeah.
We talk all the
Donnie,
time.
I'll
So
put
just
you in.
FaceTime me with everything that you have. I really appreciate it because I love this.
All right.
It's a hobby.
Sounds good, Donnie.
All right,
Appreciate
man.
it.
Take care.
We'll see you, man. Yeah, I'm not sure if that's a favor to put people on this same list. I've been trying to get off this list for years, and eventually I just said I'm going to roll with it. But oh man, okay. Here's where we are. Let me look at my schedule. We should be live in about half an hour. So give me just a little bit of break. We're going to portal over to the placeholder for the Las Vegas trial. Roughly in about half an hour, it's going to start. And then we're going to start with the Robert Tellis trial, which is what we're waiting for. It is in a Pacific time zone, so it runs a little bit later. I do apologize to all our East Coast friends, of which I am one. These hours are killing me. I know now. I know how you feel out here on the West Coast when we have East Coast trials. But we're going to portal over to the placeholder. Will be starting up just as soon as it starts here. What's the warrant for? I don't know. They haven't been calling me about selling my house anymore. Although Dwayne is the one that had the property in Ogden, Utah that was dilapidated I think it was under foreclosure or something like that. So they normally call me about that. Now they call me about these travel opportunities, but I don't know. I didn't think far enough ahead to think what the warrant was for. Probably something about scamming a casino, I think. Counting cards in a casino or something, which isn't illegal, right? All right, we're going to break, and I guess we need to just play the music, and that would be all we need to do. All right, thank you everybody for this fun morning as we filled a little bit of time as we wait for the Robert Tellis trial to start, which should be in about half an hour. Look forward to. My ears are still ringing from the lady yelling at me on the phone. She was so loud, and then when I asked her to go louder, she did. It was terrible. All right. Tonight when you go home, please hug the people you love. Smile at someone to make their day just a little bit better. And please stay safe to go live again just in a little bit with the Robert Tellis trial. Day 4 is about to begin. We'll see. We've already got some great people over in chat. So when we make the portal over, you'll have friends to talk to right before we get started. So have a good one. We'll see you in just a moment. Bye-bye.